First matter, your lordship may kindly see. I am challenging the order dated 17/3/2000.
Charge has been framed.
No charge has been framed. Cognizance.
The first matter I am looking at,
Well,
you have said that
I have submitted charge sheet against the accused person and cognizance has been taken.
but
First,
just see the prayer. The prayer says,
prayer that
please
is
quash the order dated so and so, JMC so and so, framing the charge against.
no, that is wrongly that has. I'm sorry, but my associate has not. That is even though accepting for some illegal prayer.
You be sure whether charge has been framed or not.
No, not framed.
Show me the 17/3/21 order.
Then your lordship come to page
Yes,
13
yes,
of my
I got it.
Accused person namely Krishna Chandra Paika is present. Peruse the case record with the charge sheet. I was submitted.
Charge already framed, my lord.
498 charge has been framed.
Fine.
This order, my lord, charge is already framed. Wait, like, content of the charge is
framed.
To the accused person.
Already framed.
Framed.
Sorry.
He has to file a revision, my lord.
ठीक है.
You have already filed revision.
No, revision.
Charge is revision करेगा ना.
Against charge, you have to file revision.
Revision.
Because
Not 482.
482 is maintainable, my lord.
No, why? Alternate remedy is why 482.
Because my
Under the sky, everything and 482.
नहीं कहीं की वो कहूँ suppose my nomenclature is wrong. Then this honorable court has
We nomenclature changes, judge is also changed.
Pepsi Cola case is the.
That's right, but nomenclature changes, judge is also changed. That's the problem.
I think so that judge has not been changed.
No, now revision will go to some other court. I can't enter it.
Can I pray?
Yes.
I'm going to file a IA to convert this CRLMC.
It's not fair.
It's
not fair. Try to understand.
Because, my lord, my certified copy.
Yeah, I may see.
That can be
482 court. 482 is a wider jurisdiction.
My lord.
But if since there is a revision, specific revision provision is there, why are you? This is again a kind of bench changing situation. So therefore, don't do that.
नहीं मैं IA फाइलिंग करके revision तक convert करिया पाए.
नहीं, I'm making a order for conversion and it will be re-registered and.
Yes, that can be.
Isn't it?
Otherwise, your lordship, 482 and revision, both the cases
no otherwise.
are maintainable.
The order is otherwise.
Prior to coming to
the petitioner has challenged the order dated 17/3/2021. Passed by JMFC Navarpur in GR case number 5 of 2019, whereby the trial court has framed the charges against the petitioner. Against an order by which charge has been framed, revision lies. Therefore, Land Counsel for the petitioner submits that the nomenclature of this petition may be changed. Next, accordingly, the nomenclature of this petition may be appropriately changed. Accordingly, it is directed that the registry may change the nomenclature of the present petition appropriately and place the matter before place this matter before the assigned court, subject to the approval of the learned ACG, the Honorable ACG.
Automatic. Second item is maintainable. Second item, my lord. Both the matters have been tracked.
Second matter. Okay.
Second.
What is this? Yes. Here, what is the correct?
I am playing the very issuance of the notice.
Entire
Proceeding. That is phase 9.
If you succeed in the revision, this will also go.
नहीं ता भीतर मत maintenance टा दावा पड़ियो. In case of 493, 4376, whether the maintenance is maintainable or not, it is to be seen.
What do you want to see here?
So my humble submission before your lordship.
Private.
Prior to coming to this case, your lordship come to page 21 of my brief, annexure 2.
Yes.
21. What is the offense? 294,
493,
417,
yes,
506, 34. Police has the power 493 or he made to state to 376. Then your lordship come to page 23 of my brief. Can I place before your lordship?
Yes.
So and so, then I am ମୁଁ ନବରଙ୍ଗପୁର ଭଗବତୀ ସାହିର 2016 ମସିହା ପ୍ରାଇଭେଟ ଜବ୍ କରି ଘର ଭଡ଼ା କରି ରହୁଥିଲି। ଇତିମଧ୍ୟରେ ତେନ୍ତୁଳଖୁଣ୍ଟି ପାଖ ଖୁଣ୍ଟିଆଗୁଡ଼ା ଗ୍ରାମର କୃଷ୍ଣଚନ୍ଦ୍ର ସୁଆଣ୍ଟ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ମୋ ପଛରେ ପଡ଼ି ନାନା ପ୍ରକାର ପ୍ରଲୋଭନ ଦେଖାଇ ଫୁସଲାଇ ପଟାଇବାକୁ ଚେଷ୍ଟା କରିଥିଲେ। ତାର ଜାଲରେ ନ ପଡ଼ିବାରୁ ମୁଁ ରହୁଥିବା ଭଡ଼ା ଘରେ ଆସି ତାକୁ ମିଳିଥିବା ସରକାରୀ ବନ୍ଧୁକ ତତେ ତୋ ପରିବାରକୁ ସରକାରୀ ବନ୍ଧୁକ ତତେ ଓ ତୋ ପରିବାରକୁ ଜୀବନରେ ମାରିଦେ ବୋଲି ଧମକାଇ ଡରାଇ ମୋ ସହିତ ଜବରଦସ୍ତି ବଳପୂର୍ବକ ଦୈହିକ ସମ୍ପର୍କ ରଖୁଥିଲା। ଇତିମଧ୍ୟରେ ମୁଁ ପ୍ରେଗନାଣ୍ଟ ହୋଇଥିଲି। ତାପରେ ସେ ଉପାୟ ଶୂନ୍ୟ ହୋଇ ପ୍ରେମ ବିବାହ କରିଥିଲା ଏବଂ ଏକାଠି ରହୁଥିଲେ। ଏମିତି କିଛି ଦିନ ରହିଲା ପରେ ପ୍ରତ୍ୟେକ ଦିନ ବୁଲେଟ ଗାଡ଼ି ଓ ସୁନା 10 ଭରି ଆଣିଲେ ତତେ ମୁଁ ସମସ୍ତଙ୍କ ପାଖରେ ସ୍ତ୍ରୀ ବୋଲି ସ୍ୱୀକାର କରିବି ବୋଲି କହିଲା। ନଚେତ୍ ମୋତେ ମୋର ଗର୍ଭ ଥିବା ଛୁଆକୁ ସରକାରୀ ଦେଇଥିବା ପିସ୍ତଲରେ 2 ଜଣଙ୍କୁ ମାରିଦେବି। That is the allegation. So my humble submission before your lordship, the basic ingredients of the 498 or wife, you know, 125 also. The language is very much clear. That is the legal married wife. So my humble submission before your lordship.
According to you,
no marriage is there. That is the case of
no offense is made out of this allegation.
नहीं offense मु कहूनी offense तो पड़ेला revision रे पड़ेला साइड पड़ेला नॉले
how can I test it now?
नहीं I am placing before your lordship. So very issuance of the notice under section 125 claiming maintenance from me, that is page 8 annexure 1.
Maintenance issue is something different. You in a quashing petition you want that I should interfere in the maintenance order?
नहीं maintenance I am saying that maintenance case is not maintainable in the eyes of law. Your lordship come to page 8.
So, but what are you challenging? You want
I am challenging the
FIR to be quashed.
नहीं FIR quashing
entire proceeding to be quashed.
नहीं FIR quashing करूँगी.
See the prayer. Come to the prayer. Come to the prayer.
Criminal proceeding number so and so initiated against.
What is this proceeding? 110.
That is 125 proceeding, page 8 of my brief. Page 9 is the very important. Application under section 125, the Code of Criminal Procedure Code, claiming maintenance. I am challenging the very initiation of the proceeding, my lord.
She says that marriage has taken place under the gunpoint. There is a child, and it would be tested in the trial. And you want that 125 is not maintainable. He is legally wedded wife.
No. Where is that allegation, my lord?
That's what she says. You married Premo Just see. She says that there is a child also from the marriage. देखो ता जालरे न पड़िबारु मु रहउतवा
Then it's a case of 493 or 376.
परिवार जीवन मार देबी बोली इति मध्यरे मु प्रेग्नेंट होई गेली ता परे से उपाय शून्य होई प्रेम विवाह करितिला. Marriage is, she says that married, she got pregnant, therefore उपाय शून्य होई प्रेम विवाह करितिला.
Then your lordship may
marriage is there. There is a child, and now in 482 I'll quash 125 proceeding.
Why, my lord, I am saying so.
Only ground for quashing 125 proceeding is if the wife has withdrawn from the society of the husband voluntarily. 125 is not maintained.
That is 125. That is 125.
That is the only test.
My lord.
Satisfy if that test is there or not.
My lord. So your lordship first of all come to page annexure 2 of my brief.
Yes.
What is the offense? What are those offense? 294, 493, 417, 506, 34 5.
That's not required. You are challenging 125 proceeding.
No, if this is the FIR, if this is,
you can I test the 125 proceeding vis-a-vis an FIR?
Because otherwise, my lord, I am submitting before lordship. This is the allegation.
You are stretching too much.
No, stretching korchi 482. Why, my lord, I am saying so?
So that's the reason perhaps the parliament is now curtailing the power of 482.
No, that is wrong. 482, why it has been incorporated, my lord? 482, 483 are both are.
The best thing what I could do is I will simply urgent the matter, await the outcome of revision. That's the best.
Yes. That will suffice entirely.
That's the best thing. Instead of passing any order, but this petition has to go today or tomorrow. It has to be dismissed. You choose the best auspicious day, that day will dismiss.
ताले समझ तो पड़े आसु से थरे.
You choose the day, we will dismiss in that day.
As your lordship pleases. I cannot say.
Put it after that 22nd February. 22nd February. Simply adjourn, you pursue that. If the charge is dropped, you may have a case.
My lord. तू कौन छिड़ाई पड़छ जो
Yes.
May please lordship. It is a Belgium matter, lordship.
Yes. When you are on bail, what is the offense?
Offense lordship 3762 lordship.
326. Bail के wait दिला?
Impugn order is running page 12 lordship.
नहीं
बारह
impugn
पेज
order
रखी।
छोड़ा तो ना bail के bail.
Dindi के 10
Bail के wait दिला.
कुछ action on call, no steps is taken by the defense advocate.
Are you on bail or not?
Lordship, I was
When the bail was granted? That's what I'm asking.
in fact that order is not annexed, lordship.
He should not solve the copy, my lord, also.
Chalo, where is the offense? When FIR is 2014 FIR.
Lordship.
1000. 1000.
Sir,
Right.
pardon to lordship.
Petitioner is on bail. However, he did not appear in the court on 18/10/2022, lead to issuance of NW, passing and 1000. Yes.
Lordship, inadvertently the GR case number and court name is not mentioned in the proceeding of this case, lordship. I'll memo, lordship.
Take the memo and correct it. Yes. Next. Be careful now. Yes.
May I please, your lordship, my lord? My lord, the present petitioner in this petition challenge the order of cognizance dated 31st August 2020.
Yes.
Learned GMFC Bhadan has taken cognizance under section 55 of Odisha Excise Act, whereas the allegation made a case under section 52 of the Act, my lord. This is the sole grievance, my lord.
55 is the
55, my lord,
55 is invoked against you.
my lord,
You say that it's not 55, it is 52.
no,
That's what you want to say.
my lord. 50,
Show me. Then what is 55 and 4? Let's see.
my lord, 55 prescribed punishment for
Huh.
altering or attempt to alter any denatured spirit. Whereas, in my case, the sole allegation against me is that I possess some liquor without any authority. In the final PR
The-
also,
Saying that, my lord, the wrong section, in wrong section, the cognizance taken, my lord, direct to trial court to,
Charge.
while
You
questioning
argue
the,
on charge on this. This is a
Madam.
fantastic point.
my lord, charge is,
Fantastic point you argue. I will not go into the
Madam,
details of the case.
let them direct to take cognizance under the
How can I take cognizance? Court?
challenge karo.
Take cognizance in this section or that section?
Charge order bolle petitioner है जी.
You challenge it. See this. The charge stage you can argue this,
my lord,
but cognizance stage it can't be.
my lord.
Neither the
But-
482 court can involve. So, Learned Counsel for the petitioner submits that the Learned Court of JMFC, which court I don't know.
Bhadan.
JMFC, which is this place? JMFC?
Bhadan,
Huh?
Bhadan.
Bhadan. By the order dated 31/8/2020, has taken cognizance of offence under section 55 of Orissa Excise Act 2008. However, the allegation and the documents placed by the investigating agency against the petitioner apparently attract only the offence under section 52 of Orissa Excise Act. Full stop. Therefore, the cognizance order is bad in law. Full stop. Next, I'm of the considered view that whether the provisions under the offence under section 52 of Orissa Excise Act or 55 of the said Act is attracted against the petitioner is to be elaborately dealt with at the time of framing of charge. Therefore, the petitioner the petitioner is granted liberty to
raise all this point before, at the time of framing charge.
raise this point before the trial court at the time of framing of charges and disposed of.
Well, obliged.
Item 4.
Make peace, Your Lordship. I pray for an adjournment.
Adjourn.
Obliged.
March.
Item 5.
Yes.
This is offense under section 341, 294,
What do you want? Washing.
quashing. May I please, Your Lordship. Your Lordship, there's a case and counter case, my lord. The petitioner is a wife, and husband has also filed an application under 482 for passing, my lord. Inadvertently, another number, my lord, instead of 1931 of 2023, it has come up with 1981 of 2023, my lord. 1931 of 2023 is the correct number.
Okay, 81.
81.
Arey, wo correct it here and list it. They have settled the dispute.
Yes, ma'am.
They have settled the dispute, list it tomorrow or day after, anytime. Day after. 1981. The cause is this. Connected matter, CRL 1931. In fact, it is 31.
Yes, my lord.
Okay, correct it. Land counsel for the petition submits that the connected matter with this the present petition is in fact criminal MC number 1931 of 2023. However, 1981 of 2023 is get tagged with this. Please the matter day after tomorrow kar do, along with 1931.
Yes, ma'am. 1931 of 20.
If they have settled, where are they?
My lord, they have filed the husband has deposed before the family court that they are ready to settle, or in case of.
What about a wife?
Yes, my lord, wife has also filed an affidavit to that regard.
Will they come?
My lord, if your lordship want.
No, in the VC also they can join.
Yes, ma'am.
Let them join VC on
Ye-
day
ye-
after tomorrow.
Yes, ma'am.
Okay. Ask them to join in VC if they
Yes,
can't
ma'am.
come.
Yes, ma'am.
If they can come, it's all right. If they
Yes.
don't come, then VC. No
Yes.
problem. Yes.
Aadhaar card also produce.
Aadhaar card, in any case, Aadhaar card is.
Yes.
Okay.
Grateful, Your Lords.
Item 7.
Pass over.
Item 8.
Yeah, okay. Yes.
May I please, Your Lordship? Prior to coming to this case, Your Lordship may kindly see the date of affair. I will say the merit
What do you want here?
for quashing of the entire proceeding,
Enter.
because this matter related to 2011. The affair was initiated on 23rd.
What is
Eh,
the state?
Nothing.
Charge has been framed?
No.
No, my lord.
Cognizant.
For that reason,
Correct.
this honorable court called for a report. After 12 years, 13 years, what
Hmm.
are you doing? My lord, page 24, annexure 2.
Now read the last order, what is?
Last order.
A that for the petitioner submits that in the response to the summons, the petitioner had appeared on before the court below, and thereafter steps have been taken on their behalf on all dates, but till date no witnesses have been examined, and the trial stands still. And
Till today, not a single witness has been examined. This is the sorry state of affair on behalf of.
What is the offense?
That offense is, my lord, your lordship may can see. Even though offense is not made out against me. 286, 287, 120B, 34 of IPC. Read with the explosive
What is the allegation?
allegation, my lord, I have annexed the FIR.
Hmm.
That has been initiated on behalf of the police.
Read.
Page 11.
Hmm.
I see Sarangdara Panigirai, inspector in charge of the Itlagat police station.
You don't read it. Tell me what is the FIR.
The allegation that in the stone quarry, the person who was taking that lease, in order to extract the stone, he was using the explosive substance to blast the stone quarry. And it has been alleged at the point of time, the vehicle of the present petitioner was there. Because they are unloading the stone quarries materials and shifting to the person, those who are entitled for the sale. My humble submission before your lordship.
Now, what happened thereafter?
Thereafter, my lord, the investigation was set
Whether
into motion.
it exploded?
No, not
Any
exploded,
damage?
nothing else, my lord.
Any damage?
No, not damage.
Only it was
Found.
found.
So far as my case is concerned, my lord, neither I am the owner of that stone quarry, nor I am using that stone blasting at the point of time in that stone quarry, nor anything else. 120B. Allegation against me, at best is a case of 120B. In order to suffice the 120B, the prosecution has to comply the 120A of the Indian Penal Code.
What about the other accused?
Other accused, my lord, I do not know. Because your lordship may can see, from 2011 till today, even though accepting for a moment the entirety of the prosecution case, what the state is doing? Nothing, my lord. The cognizance has been taken on 31st/3/2015.
Then
Your lordship knows that.
You said that you are not the owner of.
No, not the owner. That has been,
Leaseholder. Who are they?
my lord,
Juma Ali, Abdul Salim, you are Ajay Goyal,
my lord.
and three of you.
Nothing.
What is the role of these 2 and 3?
My lord, your lordship, it will suffice from the FAR that the owner of that stone quarry using the blasting.
Who is that owner?
Owner, my lord, that is against allegation, my lord, I am placing.
Where is the charge sheet?
23rd, page 23, my lord. Brief facts of the case. Got a reliable information that one Jamuna Ali of Neurnagar, Titlagora, was digging the hole in the stone quarry of one Tinnu alias Lakshmana Narayana Jain. That my,
Okay, it's all right. This is the FIR.
my lord.
Where is the charge sheet I want to see?
Charge sheet 23, page 23, my lord.
Page 23.
I have annexed that entire charge sheet, my lord.
Let's read the 23, page 23. Page 23.
3.
How many charge sheeted accused? 3.
Altogether, my lord.
How
4
many
person.
charge? How many charge sheeted accused?
4 person.
4.
4.
You have,
Including me. 3 is the 3 persons owner of that stone quarry. Those who are using that.
who is the owner?
That is Lakshmi Narayana Jain.
You have Lakshminarayan Jain has not approached this court now.
No.
You three.
No, I am one, my lord. I am placing for the one, my lord.
No. You have, the petition is for 3.
3, my lord. Huh?
You are pressing for
3 person.
only
3.
Ajay Goyal.
3 person, my lord.
That's what I'm saying.
My lord, my lord.
So along with that, Lakshmi Narayan, who is one more accused.
My lord.
So you have not filed petition for.
No.
You have filed. She is the owner. That's what you want.
He is the owner, my lord.
Okay, now let us see. What is this charge sheet says?
Charge sheet is under section, my lord. Page 23 towards that.
Yes, come to the charge sheet.
As evidence,
Hmm.
under the above circumstances, as evidence, under section 286, 287, 120B, 34 of IPC, read with under section 3A/5A/6 of the Explosive Substance Act, well established against the accused persons, and submitted the charge sheet.
Hmm.
Till today, I am moving here and there.
There are about 11 witnesses.
My lord.
Charge has been framed.
No, only cognizance, my lord. From 31st, the FIR was lost in year 2011, my lord. 23rd/8/2011 by the IIC.
Yes, Mr. Ragada, what is this?
Allegation that my lord, as per charge sheet, on such, he along with his.
There are 2 issues. One is allegation. It's all right. Allegations we will check in. 2011 is the FIR.
My lord.
And
Continue
today
the
we are in 2024.
My lord.
You don't do anything.
My lord.
And how will you give justice to these people?
That is
Wrong,
my lord,
right,
but
whatever.
impact,
And
my
the
lord,
allegations are very simple allegations.
My lord.
For that, you take 1 decade.
My lord, the target may be
Target. What target?
3 months, my lord.
What target, my lord?
At best,
You-
3 months, my lord.
You have not framed the charge also. There
My
is
lord,
nothing. What is this?
My lord, so that is what, my lord, I will take instruction, my lord, regarding whether.
Come tomorrow.
My lord.
Come tomorrow. I will quash it if you
My lord.
don't give proper answer.
But
What
they
is
have-
this?
Can't
You
day
can't
Can't
allow
they-
this kind of prosecution
My
to
lord,
go
I
on,
know.
burdening the system.
My lord. A day after tomorrow, my lord.
Day after tomorrow.
Day after tomorrow, my lord, I may not available. On
Day after tomorrow is
Thursday,
29th. na?
First.
First.
first, my lord.
First. But
That-
get
My lord.
concrete
Madam.
instruction.
That Supreme Court judgment, your lordship knows. And
What Supreme Court will do, and just see it is apparent from the record. The allegation I can understand if it's a very heinous
My lord,
allegation,
my lord,
one can understand. The
My lord.
small allegations and you take more than 1 decade.
my lord.
May I?
Yes.
Let's say it's a case where charge sheet has been filed, cognizance has been taken. So now the role of the prosecution has completed. Now the
Role
judicial
of the
proceeding,
Role of
who has
But how?
actually
Yes,
who has delayed and for whom the
That
case
is
has
that
been
is
taken.
the reason.
want to.
Your
That is
lordship
the
may-
reason I have urgent for day after.
No,
He has
but
filed the
that is-
proceeding.
Your lordship may
Check
kindly
it.
call for a report from the trial court.
that
Why it
Also
is
limited,
limited?
my lord.
Your lordship may call for a report from
You
the trial
can't blame
court
the court.
because this is the proceeding has
It
been
is very
stayed.
easy to blame the court.
No, I
you could have done it.
My lord, I will take it.
You just see the proceeding
My lord.
and tell me if it is attributable.
I will present.
If the delay is attributable to him,
My lord.
then he is
Exactly.
gone.
Yes,
If
I'm like,
delay is attributable to prosecution,
Well,
then I'll pass it.
Yes,
Well,
exactly.
Very simple, nothing else.
Exactly. Exactly.
If he has delayed it,
Well,
he has to suffer it.
my lord,
As simple as that.
my lord. Thursday, my lord,
First,
first, my lord, obliging.
yes.
Item 9.
Item 9 may be taken up day after tomorrow.
I will adjourn it, but day after tomorrow, I'm not sure.
Tomorrow.
Because we are following a system. We'll see when we can adjourn. Yeah.
Passover, only Passover.
Passover,
After the recess.
Passover, Passover. Yes,
Item 10.
No, no, 9.
yes, 10.
May I please, your lordship?
Yes.
Challenging the order of cognizance on two folds.
Yes.
Here, my lord, the petitioner, the wife of the
Where is the
informer
charge sheet?
suspect.
Show me the charge sheet.
Charge sheet I have not, but the cognizance has been
Cognizance
taken
is taken in the FIR or charge sheet?
in the charge sheet.
Where is the charge sheet then?
I will file that.
Without filing charge sheet, how will I check the cognizance is correct or not?
I will file it.
File it, urgent. Next,
Item 11.
Item 11, your lordship, pray for a Passover.
Passover. Okay.
12.
Yes. Passover.
13.
Lordship, item 13 also kindly be taken up to next week.
Adjournment.
Adjourn.
You want an adjournment? Adjourn.
Item 14.
Yes, ma'am.
It is for quashing of the FIR.
Yes.
My lord, initially, the informant lodged a FIR against me.
Yes.
That is Annex 1.
By the way, why have you taken so many adjournment in this case?
Adjournment. My lord, because of my personal
Okay.
problem.
Okay, sorry. Yes. Yes, tell me, ma'am.
My lord, for quashing of the FIR,
Hmm.
your lordship may kindly turn to Annex 1.
Mr. One.
Annex 1, page 21. My lord, allegation as is revealed doesn't make out a case under 376,
Yes.
But-
let us-
but 376 has been added.
Yes, let us see 20, page 20,
Yes.
20.
21, my lord, mine page is 21. It is a transfer brief, so I am in difficulty whether it is your lordship's brief 21 or 20.
This is the complaint, the ODR written complaint is at page 20.
20. So I'll change.
Mo Savitri Pradhan.
Again.
Yes, you read it.
So
Mo
and so,
Savitri Pradhan,
ଆଜ୍ଞା।
ବୟସ
so and so, so and so.
Hmm.
ମୋ ପଡୋଶୀ ଘରର ଜଣେ ବ୍ୟକ୍ତି ତାଙ୍କର ନାମ ଭାସ୍କର ମୁଦୁଲି, ପିତା so and so, PhD ପାଣି ବିଭାଗରେ ଜବ୍ କରୁଅଛି। ମୋତେ ଆମ ଘର ପାଖରୁ ଆସି ନେଇଥିଲା, ନେଇ ଗୋଟେ ଭଡା ଘରେ ରଖିଥିଲା। ଆଜିକୁ 7 ଦିନ ହେଲାଣି। 30/6/23 ରୁ 6/7/23 ପର୍ଯ୍ୟନ୍ତ ମୋତେ ନେଇ ରଖିଥିଲା। ଭାସ୍କର ମୁଦୁଲି ମୋ ସାଥିରେ ଶାରୀରିକ ସମ୍ପର୍କ 7 ଦିନ କାଳ 2-3 ଥର ରଖିଥିଲା ଏବଂ ମିଛ ପ୍ରତିଶ୍ରୁତି ଦେଲା, ପ୍ରଲୋଭନ ଦେଖାଇଲା। ତୋତେ ଭଲରେ ରଖିବି, ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ବୋଲି ରହିବା, ସବୁଦିନ ପାଇଁ ମୁଁ ତାକୁ କୋର୍ଟ ମ୍ୟାରେଜ କରିବାକୁ କହିଲି ସେ ମତେ ହଁ କହିଲା କିନ୍ତୁ ମତେ ଭାସ୍କର ମୁଦୁଲି କହିଲା ମୁଁ ଯାହା କହିବି ମୋ କଥା ମାନିବୁ ନହେଲେ ତୋତେ ଜୀବନରୁ ମାରିଦେବି ଧମକ ଦେଲା ମୁଁ ତାଙ୍କ ଅଫିସ କ୍ୱାର୍ଟରକୁ ଗଲି ତାଙ୍କ ସ୍ତ୍ରୀ ଓ ଶ୍ୱଶୁର ଘର ଲୋକେ ମିଶି ଗାଳି ଗୁଲଜ ଓ ଟଣା ଉଟରା କରି ଧକ୍କା ମାରି କ୍ୱାର୍ଟରରୁ ବାହାର କରିଦେଲେ ମତେ କହିଲେ ଆଉ ଥରେ ଯଦି ଆସିବୁ ଜୀବନରୁ ମାରିଦେବେ ବୋଲି ଧମକ ଦେଲେ this is all. Your Lordship may kindly see the date of FIR.
The incident is according to her
Yes,
from 30th June
30th June 267.
30th June to
267.
no, 30th June to 23 to
67.
6/7/23.
Yes.
Okay.
Then your Lordship may kindly turn to annexure
Yeah, the FIR is on 8.
8. FIR is on 8. Before it, your Lordship may kindly see
Yes.
the FIR dated 6/7/2023.
That is at page 25.
Yes.
This FIR is dated
6/7/2023. That is another FIR. My lord, she is onward.
no, this FIR if you are talking about this FIR,
Yes.
see it's 2016.
16. My lord, that is by the informant against another person, and she became the unwed mother. He is a different person. Sampal.
And the same lady has given an FIR earlier also
Earlier.
against someone else. Similar kind of allegation. What happened
Yes.
to that FIR?
That FIR I cannot say, but the man is absconded
In
That's-
that FIR.
because in the meantime she became a mother, unwed mother of that person.
Okay.
Then your Lordship may kindly turn to page 30 in your Lordship's brief, that is 6/7/2023, by the wife of the present petitioner.
Which one you are reading about? Annexure 4.
Yes.
Annexure 4, yes.
Sumitra Muduli.
Yes. What does it say?
Yes. This is FIR is dated 6/7/2023. Your Lordship may kindly mark this.
6/7/2023.
2023. And this FIR is 8/7.
Okay, I understood.
Yes.
Yes. What does it say?
Yes. ସୁମିତ୍ରା ମୁଦୁଲି ସ୍ୱାମୀ ଭାସ୍କର ମୁଦୁଲି ସୋ ପ୍ରକାଶ ତାଉ କି ମୋର ସ୍ୱାମୀ ଭାସ୍କର ମୁଦୁଲି ମୋ ଶାଶୁଘର ପାଖ ପଡିଶା ଘର ସ୍ତ୍ରୀ ଲୋକ ସାବିତ୍ରୀ ପ୍ରଧାନ ମୋ ସ୍ୱାମୀକୁ ବହୁତ କାକୁତି ମିନତି କରି କହିଲା ଭାଇ ମୋର କେହି ନାହାନ୍ତି ମୋତେ ପୋଷିବା ପାଇଁ ତେଣୁ ଭୁବନେଶ୍ୱରରେ ମୋ ପାଇଁ ଗୋଟେ ଭଡା ଘର ଠିକ କର ମୁଁ ପର ଘରେ ବାସନ ମାଜି ଓ ବାହାରେ କାମ କରି ମୋ ପିଲାକୁ ମଣିଷ କରିବି ଏକଥା ଶୁଣି ମୋ ସ୍ୱାମୀ ମନେ ମନେ ଚିନ୍ତା କରି ଗୋଟେ ଘର ତା ପାଇଁ ଠିକ କଲେ ଏବଂ ସେ ସେଇ ଘରେ ରହିଲା ଏମିତି କିଛି ଦିନ ରହିବା ପରେ ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଯେଉଁ ସରକାରୀ ଘରେ ରହୁଥିଲୁ ସେଠାକୁ ଆସି ମୋତେ ଅଭାଷା ଭାଷାରେ ଗାଳିଗୁଲଜ କରିବାକୁ ଲାଗିଲା ଏବଂ କହିଲା ତୁ ବାହାରି ଯା ଏ ଘରେ ମୁଁ ରହିବି ତୋ ସ୍ୱାମୀକୁ ମୁଁ ବିବାହ କରିଛି ତେଣୁ ତୁ ବାହାରି ଯା ନହେଲେ ତୋତେ ଜୀବନରୁ ମାରିଦେବି ଏହା କହିଲା ପରେ ପୁଣି ତାର ମା ରୂପେଇ ସୋଆଂଶୋ ଭାଇ ସୋଆଂଶୋ ଭଉଣୀ ସୋଆଂଶୋ ରାତିରେ ଆମ ସରକାରୀ ବାସଭବନରେ କବାଟ ଭାଙ୍ଗି ମୋ ଉପରେ ମରଣାନ୍ତକ ଆକ୍ରମଣ କରିବାକୁ ଲାଗିଲେ ମୋତେ ଟଣା ଉଟରା କରି ଅଭାଷାରେ ଗାଳିଗୁଲଜ
Yes, I
କରିବାକୁ
understand.
ଲାଗିଲେ।
Yes, Mr. Garuda, but the
this-
only
my
problem is you
My-
have to implead her. What? Savitri Pradhan, where is she?
My lord, up to my
She is
lord,
appearing.
My lord,
Savitri Pradhan.
my lord,
not
Somebody, you have to serve. What is the position? Savitri?
my lord, what I beg from the my lord,
Huh.
till 15/7/2023, I have received the case diary, my lord.
Hmm.
Case diary reveals that it is a prime phase case 493 294 506.
493.
My lord,
yes,
493.
Max-
376. See, that's what she says.
yes.
This is not there, my lord.
376 is not made out.
Not there, my lord.
ନାଇଁ
My
ଏଥିରେ
lord,
ଅଛି
up to investigation, my lord, 15/7/23, my lord.
କିନ୍ତୁ
The
ଏଥିରେ
IO
ଅଛି-
mentioned that prime phase case
But
493.
allegation
Rape is not-
493 is made out.
My lord, that is there, my lord. Up to my lord, CD, case diary
My lord,
15/7/2023.
your lordship,
In the
may
meantime, my
kindly-
lord, charge sheet must have been submitted, my lord.
FIR has been lodged under 376 too.
That high price.
That's right. But now charge sheet,
57 during investigation that has been my lord.
My lord,
shall I
as,
record and dispose of that?
my lord, as on date, the charge sheet has not been filed.
But
And-
15/7, my lord, case there shows 15/7 during course of investigation. I found
Can I
prime facie
record
case-
your statement that no
My lord.
376 is
My lord.
made out?
My lord, my lord.
Then I'll dispose it up.
My lord,
Are you sure?
my lord, my lord, case there-
I don't know. I don't. I will record your statement. Or come and make the statement tomorrow.
That should he.
नहीं नहीं
Or that is the noting of the IO, my lord. That may be.
See, the problem is
Mal-
I can't make any direction because it is at the investigating stage. I
Mal-
can't make any
No, Mal-
direction or anything. And if you are making a
Mal-
statement on the basis of case record, I'll do. Otherwise, no 376.
Day after
will be
tomorrow, my lord, I will obtain
and
instruction.
see the characteristic of this lady. She involved someone else earlier.
But for that is in
And
493, my lord.
2 days before, the wife of the victim, the petitioner,
Petitioner.
she makes an FIR.
For that is in
And
493.
after just 2 days, another FIR 376. What is this?
For
My
that
lord,
is
what
in, my
has
lord.
happened background is she is having a son and the petitioner having no children.
I understand.
My lord, day after tomorrow, my lord, from Kotak Southern, I will take instruction. From there.
Ask the IO
My lord.
and
One page in
day
notice.
after tomorrow
My lord.
with
Day after.
full written, because otherwise you will be in
My lord,
trouble.
for that is my lord.
So written and what is this service position? Why she is not appearing?
Notice has been issued or not? Like that? Jaini. OP number 2.
ଯାଇଛି?
No, Jaini bodhe. Notice bodhe.
Issue notice to opposite party number 2. ଆପଣ second ପାଇଁ କରନ୍ତୁ written on 2nd of February. Meanwhile, Mr. Ragada would seek instruction
No
regarding the status of the investigation.
My lord, no coercive action shall be taken as against the petitioner.
Mr. Ragada, just see,
My lord.
make sure
My
that
lord,
instruct your,
Mal.
I will,
Today I will.
by standard,
My lord. I-
this thing I will not pass an order, but instruct your
No, no.
IO not to take any.
My lord, no course.
Obliged. Keeping it to second.
Let us trust him now.
Yes.
My lord.
Your lordship is
But
keeping.
this is a very,
Check, my lord. If not there, my lord, your CV. Other person will remain and 370.
no, 2nd February we will
Mal.
pass it.
My lord.
Insofar as 376 is.
See,
My lord.
yes. Obliged.
If not there, my lord, then
No, then it's
application
all
is-
right. Her grievances are attended.
Mal.
Obliged.
15.
You have to file the process today so that notice should go.
My lord, notice should be served through the government. I will serve a copy on him.
Notice
copy.
to the opposite party number 2 should also be served through the IO of this case.
To the Mr. Tagoda.
He's saying that, my lord, he's saying.
No,
he's
to
saying that
IO, he will give
if
it to IO.
notice, extra copy will give.
Investigating officer will serve.
Nana ko investigation letter de debu copy.
Extra copy ଟା ଦେଲେ
ଆପଣ କପି ଦେଇଦେଲେ IO କୁ ଦେଇଦେବେ।
Extra copy will be.
IO
Send extra copy.
IO through service ହଉ ନା?
Again.
15.
May I please, ma'am?
Yes.
Here I have challenged the order of cognizance
Yes.
taken against the petitioner if offences under section 379 and subsequent issuance of NBW matter. Madam, we turn to page 7.
Again the same question, sir. Cognizance is taken on charge sheet or FIR?
Charge sheet?
Very charge sheet.
Charge sheet. And I have to file. I have to file.
Urgent.
A short date.
So that
16.
you have to instruct your office
Yes, sir.
now that whenever there is a
That's
cognizance order
Charge
challenge,
sheet.
charge sheet has to be.
Usually we file it, but we will file it. Anyway.
Your juniors might not have done.
No, we will file it. Transport. Be cautious. And
Yes.
when this is a case matter where offense under section 307 has been added, added, and Madam, let's see the page 11.
You have filed the injury report, but not charge sheet against
Charge sheet.
cognizance.
Here, my lord, I have limited prayer because in the meantime, petition number 2 has been arrested and released on bail by the court below. My purpose will be solved if my lord direct petition number 1 and 3 directly that saying that so far petition number 2 is concerned because he has been arrested and released on bail, not press. So far 1 and 3 may be permitted and move for bail before the court below, which will be disposed of maintaining parity.
There are 3 accused.
3 accused, 2 has been arrested and released on bail in the meantime.
What is the injury?
Injury, my lord, simple, madam, may I see.
Where is that?
Now,
Page
Your Lordship, before going to
11.
the merits of the case, and the petitioner conduct is very bad. He has not obeyed the order of this honorable court.
Where is
Twice
that?
the anticipatory bail has been filed.
Rejected.
No, twice on merit, one rejected, one directed to be surrendered. That has not been complied. And no certificate has been given.
What do it will help?
Twice, not single.
Sorry, sir.
That is the minimum.
But my humble submission, so far the CLMC concern is I filed once ballot, I have no case. And in the meantime, ballot,
No,
out
no,
of
no, what he says that you will not disclose anything, and then it is a problematic thing.
no, my lord, I have
You will not
said so.
disclose.
He has been granted interim protection for 3 weeks. Thereafter, the matter disposed of granting surrender within 3 weeks, not surrender. Then, my lord, this application, twice the application has been filed.
I will
before.
not interfere.
No, in view of the changing circumstances, the prisoner number 2 has been arrested and released on bail, my lord.
Maybe,
My
but
humble
this is the
submission.
your conduct. Why should the 482 court will be lenient? If this is the conduct, you don't respect the court's order like this, and
No,
you don't disclose it also.
That is not my instruction, but whatever, my believe
You
that is.
withdraw, Mr. Chand submits that in the meantime, the one of the co-accused has already been granted bail. Therefore, since these petitioners, the role attributed to this petitioner is similar to that of the co-accused, he is entitled for parity. Insofar as the bail is concerned. Mr. Maharaj vehemently vehemently contradicts this submission and informs the court that earlier indulgence of this court to these accused persons have been misused in as much as the interim order granted to the petitioner for 3 weeks has not been complied.
Yeah, interim order for interim protection that was.
Interim protection granted 3 months has not been.
No, that is there.
That is on order dated 7/5.
Hey, what happened? They were not surrendered
No,
thereafter.
no.
The interim order granted by the order dated
Order dated 7/5/2021.
Final order.
23 for 3 weeks.
That is the final.
I must say final order, interim order.
Has not been adhered to. Okay. I'm not entering into the controversy raised at the bar. However, not at the bar. Mr. Chand seeks to withdraw.
Let me say surrender and books
No,
of it.
seeks to withdraw this petition to avail the remedy available to him under law. Accordingly, the petition is disposed of. Yes.
17.
May I please, my lord? In this case, I am not challenging any order, my lord. The NBW has been issued against the present petitioner on that day, December.
What is the offense? What is the
Offense under section 365, 364.
Okay, 365 and all. Bail? When you got the bail?
No, my lord. I am not in bail, my lord.
You are absconding.
Yes, my lord.
Then you won't.
My lord, first hour, second hour order. First hour, second hour order.
First hour, second hour. I am not here to, NBW has been issued.
On that day,
Dekho,
December 2, 2014.
petitioner,
Twice the bail application has been filed, no certificate is given.
what is this? At least it is expected from the
My lord,
lawyer
direction
that
given
at least
to
you disclose the right facts.
surrender before the law and court.
No, you do whatever, I am not on that. But if you have taken the orders from this court, then you have to disclose these things.
And the same order was passed. First or second order was also passed. That has not been complied.
Seeking the same prayer, seeking the same prayer of quashing of the issuance of NBW by the court below. The petitioner had earlier approached this court. Full stop. Despite indulgence of this court, the petitioner has not surrendered. Full stop. Next, the petitioner has in this petition, the petitioner has also not disclosed regarding the earlier proceeding before this court. Earlier proceeding he had initiated before this court. Therefore, Mr. Maharaj vehemently opposed the prayer of the petitioner. Having taken into consideration the facts of this case and statement at the bar, I am not inclined to interfere in this matter, hence it is dismissed. Next.
18.
May I please? The order passed by the learned court below under Annex 3 at page 20 is assailed in this present application, my lord. A application under section 12 of the PWDV Act was filed by the respondent.
Okay.
My lord, the present petitioner approached this honorable court in CRLMC number 3272 of
What is
2020.
this order 12/9/23?
Yes, that I have disclosed in my certificate, my lord. And I'm handing over a copy of the order of this honorable court, the earlier order. 3272 of 2023. Wherein this honorable court, after hearing, my lord, the petitioner has passed the order directing the learned court below to take up the issue of maintainability first, my lord.
Copy may be served. Private
Private. The issue of maintainability to be adjudicated first by the learned court below in view of the provisions contained under the PWDV Act.
Which paragraph you are reading of this order, which you are saying?
Para 3 to
documents. Going to the documents referred to by Ms. Mishra, this court finds some force in the submission there, but when it is for the court.
the maintainability part is reflected at page 5, para 5 of the order.
Satisfied that the statutory requirement and the proceeding and are fulfilled. Oh, it doesn't say that.
My lord,
He left it to the court below.
my lord,
Just see para 4 of the order. Read it.
my lord, para 5.
Para 5.
In such view of the matter, without expressing any opinion on the merits of the case, the CRLMC disposed of directing the learned SDJM, Keonjhar, to consider the averment in the complaint and the affidavit and form his subjective satisfaction as regards maintainability of the proceeding in the light of the contention raised and to proceed accordingly.
In pursuant to this order, what is the order passed by the
My lord,
court?
that is the order.
Order is
Now it has been impugned before my lordship.
3/8/2023.
Yes, that is under Annex of 3, 12/9/2023.
Yes.
My lord, the learned court below has only reiterated the definitions as contained in under the PWDV Act. The main contention is that, my lord.
Second paragraph
Yes.
of this order.
In the order passed by the Hon'Ble High Court of Orissa in
This
CR.
order you are showing me.
My
This
lord?
order. This order he is
Yes,
referring
yes.
to. Yes. Next.
Para 2 of that order, my lord.
Yes, yes. Read it. The
Para?
Honorable Court has directed the court to read that order.
Yes.
You are reading.
Has directed this court to consider the averments in the complaint and the affidavit and to proceed accordingly upon the subjective satisfaction as regards the maintainability of the proceeding in the light of contention raised. The contention raised by the learned counsel for the respondent before the Honorable High Court that the present case is not maintainable in the eye of law, since it does not disclose any domestic relationship between them within the meaning of Section 2F of the PWDV Act. For the said purpose, he has referred to the affidavit shown by the complainant in Form 3, wherein it only been stated that the deponent petitioner at their ancestral residence in village Bondogoropada in the district of Keonjhar, he has argued that this cannot partake the nature of domestic relationship within the meaning of the Act, since the nature of such relationship has not been disclosed, which is mandatory for maintaining a proceeding under Section 12 of the PWDV Act. Further, he has drawn the attention of the Honorable Court to the copy of the Form 2 filed by the complainant before the learned SDJM Keonjhar to point out that there is no specific allegation of any domestic violence contained therein, and in absence of any specific allegation, it is not known as to how the petitioner is aggrieved so as to be treated as a person aggrieved within the meaning of Section 2A of the Act. Now, Lordship may kindly peruse 2A of the Act.
Yes. Don't you.
PWDV Act. PWDV Act 2005.
Domestic violence. Domestic violence. Read it out.
Well, 2A, the definition, aggrieved person, means any woman who is or has been in a domestic relationship with the respondent and who alleges to have subject to act of domestic violence by the respondent. So here, as per this definition, Lordship may now kindly see the allegation under form which has been filed by the respondent before the competent court. That is at Annexure 1, Form 2. Lordship may kindly peruse. I have given the
Where is that?
page 10.
10.
Page 10 of the brief.
Yes.
Lordship may kindly see Form 2.
Yes.
Most respectfully, the application under Section 18, 19, 20, 22 of the Protection of Women from Domestic Violence Act is being along with a copy of the domestic incident report by the tick mark has been given by the aggrieved person.
Right.
Yes. It is prayed that the Honorable Court may take cognizance of the past protection
Come
order.
to the fact. Now,
All-
come to the fact.
All my lord tick mark. There is no complaint in the whole form.
Now, what is the relationship between them?
The relationship is also not mentioned in Form 2.
We
Only,
see then.
my lord, she is, my lord,
Bhagavati Ram.
yes, she is working as a maid under the present petitioner in their ancestral house. As a maid.
Sanatan Ram.
Yes, as a maid in their ancestral house. Because my wife is living.
What is her claim? Let us see, come to the fact. Facts narration.
Only in form number 3 at page 15.
Come to the affidavit at page 15. Yes.
Yes, Lordship may kindly see para 3, what she has written. That the
Living
deponent had been living with the respondent at their ancestral residence of village, blah blah, Keonjhar town, Keonjhar. So there is no mention of any relationship. And domestic relationship has been defined under Section 2F of the Act. Lordship may kindly peruse 2F. What a domestic relationship means. May I read, my lord?
No, just Sanatan, come to page 17. What have you said?
Page 17 is the notice of appearance to the petitioner.
What have you said?
My lord?
The reply?
Reply, I have come before this court that a proceeding under Section 12 of the DV Act is not maintainable at the behest of the opposite party respondent. And this honorable court has taken note of my submission and directed the learned court below to first take up the point of maintainability. And the learned court below has passed this impugn order.
Yes, write down. Write down. The petitioner has invoked the jurisdiction of the state under 482 CRPC challenging the order dated 12/9/2023 passed by the learned JMFC LR Keonjhar in
CMC number 280 of 2022.
CMC number 280. CMC number 280 of 2022. The learned court below has passed the impugn order pursuant to the order of the coordinate bench of this court dated 3/8/2023 in KRLMC number 3272 of 2023. Next paragraph. The Mr. Mishra, Learned Counsel for the petitioner submits that the form 2 and 3 of form 2 and 3 under rule 6(1) and rule 6(4) and 7 of domestic protection of PWDVA rules. Rules would reveal would reveal that the opposite party number 2 have no way related to
Opposite party, only opposite party, sole opposite.
opposite party is no way related to the petitioner hearing. I have perused the content of the form 2, which indicates that the opposite party has tried to maintain the complaint under PWDB Act, alleging that she is an agreed person. She is an agreed person. To substantiate her claim being an agreed person, in Form 3 at Para 3, she has stated as under Para 3, page 50. Para 3, page 8. Mr. Mishra pointed out. Mr. Mishra has pointed out the provisions of Section 2F. Section 2F of the Act. 2F, no? 2F of the Act, and submits that the allegation or an oblique averments made by the opposite party in the entire proceeding, even if it's taken at its face value, will not satisfy the requirement, will not fall under the category of agreed person, inverted comma, agreed person. Full stop. That's the only reason the coordinate bench of this court, by its order dated 3/8/2023, has directed the trial court to decide the issue of maintainability before proceeding with this matter as a preliminary issue. However, the learned trial court has passed the impugn order, which is contrary to the law and very definition of agreed person. Agreed person in the provision containing Section 2F of the Act. Right. Next, issue notice to the opposite party written within 3 weeks. In the meantime, the proceeding before the court proceeding in so state. Very you serve it, but safely take your.
But requisites to be filed by day after tomorrow.
Day after. Filed day after tomorrow. Serve it.
Well,
okay.
By speed post.
By speed.
Okay.
Very good. Next.
Item 19.
Mark first in the court. Next.
I am challenging the order of cognizance under Annexure 6, page 27. The fact of the case is the petitioner is a private limited company for the financial year 2012 and 13.
Use the mic, sir.
For the financial year 2012 and 13, corresponding to assessment year 13 and 14, the petitioner has deducted the income tax, but failed to deposit in the government account within the time stipulated. So thereafter, a show-cause notice was issued. The petitioner deposited. Prior to that, there is in the show-cause there is a delay of 2 to 9 months.
2 to 9 months.
2 to 9 months for depositing the delayed deposit in the central government account.
GST deposit.
My lord. TDS, my lord.
TDS deposit. Okay.
My lord. Thereafter, the petitioner deposited the interest and the penal interest on 14/7/2016.
But both the things can go together. But these are the offences generally after deposit they quasi.
My lord.
Generally, it's a compoundable offence.
Compoundable offence.
I'll issue notice.
My lord, yes, my lord. I have filing judgment. Then I file.
But without notice, I can't do.
My lord.
I'll issue notice.
My lord. I have already sought the copy to the council for the.
Whoever it is, I'll issue notice. Have you really deposited? Show me
page
that you have deposited.
My lord.
That I can state.
My lord. That is page 16.
16?
16, my lord. Yeah, 16 is my letter and page 17 is the challan, my lord.
16.
it is a challan. Page 17,
Yes.
in the 2,66,260.
What was the due amount?
My lord, I have already deposited the TDS amount. Allegation is you have deposited an amount.
Delayed.
We delayed to 2 to 9 months. For that reason, I have deposited interest with penal interest.
No, where is the complaint?
Complaint is, my lord, pay annexure 5, page 21 is the complaint petition.
Under section?
Under section 26B of the IT Act, my lord.
ID. Look, the petitioner is facing prosecution under section 20.
276B, my lord.
Where is that? Under 276B of Income Tax Act. Income Tax Act. The allegation against him is, although he has deducted the TDS from
the salary of the employees.
From the salary of the employees,
And on the contractor, they have the.
and the contractor he has employed. However, he has not deposited the TDS amount within time and caused a delay of 2 to 9 months. Pulsar. The petitioner has pointed out from annexure 2, deposited.
And my lord, annexure 2, page 17.
Petitioner has pointed out from annexure 2 of this of the petition that he has deposited the TDS amount belatedly.
Like TDS, my lord, already deposited. It is a penal interest and interest.
Belatedly
Period.
and also suffered the penalty for that. Suffered
also
penalty for
deposit.
that. Penalty for that. Therefore, he submits that the prosecution launched against him, despite the fact that the TDS amount and the penalty amount has already been deposited, is in futility and seeks indulgence of this court. Issue notice to the opposite party, returnable within 4 weeks. Hence, requisite to be filed within 2 days. Within 2 days. 2 days. Next paragraph. Meanwhile, application logation.
My lord.
Meanwhile, the proceeding proceeding in a code of
ACGM.
ACGM IA number 3457.
57.
नहीं flag है लेकिन stay. ठीक है? Stay ठीक नहीं.
Item 20.
Private party. 20 private party. Yes.
My lord, the petitioner has been paying the maintenance amount to his wife since last 24 years. That is from 2000. The petitioner has been paying the maintenance amount to his wife since last 24 years. That is from 2000.
What do you want? Your husband?
Yes, sir. I am.
Your husband, you have to pay maintenance. What is the big deal about it? What do you want here?
Want to seeking for quash the order of the court below. There is a Noyagad family court, and as at that time the petitioner is not able to pay the amount as he is seriously ill and he is under treatment at AIMS. And although all these facts, and another fact is that the opposite party, that is the wife of the petitioner, is staying at the house of the petitioner since last 24 years.
All these things are correct, but you may have a good case, but not in 482. How can I quash a maintenance order?
Sir, is not able to. Sir, that's why.
That's the pathetic story. But what to do?
That's why I am going to.
You have to challenge that order in appropriate court, not in a 482 court. I can quash the maintenance. You admit that she is the wife, no doubt about it. She is the wife. You have to maintain, rightly, wrongly, whatever. There is an order.
Yeah.
And merely the fact that you suffer somehow you don't want to pay or you are not able to pay will not make the proceeding illegal, for which a 482 court can interfere.
Sir, court can utilize the power under section 482 to.
A petition which is maintainable, that also I can quash because I have power. You tell me 125 proceeding initiated against you. It is a maintainable petition. There is no doubt about it.
No.
If a petition which is maintainable, a order is passed, wrong, right, whatever, there are remedy available to you. If you can show me that the petition is not maintainable, still an order is passed, then I can think of to exercise jurisdiction 482. You show me any judgment or anything that you are, because of your physical ailment, you are not able to pay, you have a very hardship and all. In that scenario, the 482 court can also interfere. Show me some judgment. I'll give you time.
So,
When can you
I
come?
produce. After
With
5.
full preparation, with judgment and all. Then I can try to help you out. And you have not placed anything, what is your problem and all. Mere saying the problem will not make problem. Every husband has a problem.
Your Honor, the petitioner, the opposite.
When he suffers a maintenance, then he has a problem.
The opposite party is maintaining a luxurious life and at present.
Maybe you may be correct, but show me something on record. Nothing is there. You brought a big proposition of law. You take time and prepare and come.
Sir,
Give 1 week or.
Sir, another IA application I have filed.
Yes.
Sir, kindly.
First you satisfy me in maintaining it, then the question of stay and all will come. You prepare and come. I'm just giving 1 week. Prepare if at all. If you file appropriate documents, I have not seen any document in this case where any indulgence can be given to you. Some medical documents and everything you have filed. Otherwise, what I'll do is I'll simply issue notice. Let us see. Letter come. We'll see. Huh? We simply issue notice. Notice to opposite party. 1. Huh? Let us issue notice. Let us see. If he comes, then we'll try to work it out. Okay. Returnable within 2 weeks. You file the requisites. Let us see. Okay. I'm just coming. Yes. 21.
21 I pray for 1 week after.
21.
1 my.
Yes.
I pray adjournment 1 week, my lord.
Sorry?
I pray 1 week adjournment, my lord.
Okay, urgent.
Problem.
22.
My lord, Belgium matter on 5/9/2022, NBW issued.
NBW issued.
My lord,
What is the offense?
offense is 450, 376, 511 IBC.
Okay. Oh, bail. When you got the bail?
Prior to submission of charge sheet, prior to submission of charge sheet, I was released on bail. After submission of charge sheet, notice was issued. And after issuance of notice, he has not appeared, for which individual is issued. Annexure 1, my lord.
This is FIR is up to 2017. Okay. 1,000 or 500?
500.
500.
Public.
Yes. Yes.
23.
Yes. Yes.
NBW issued on 18/10/2022.
Bail.
Belgium, madam.
When you got?
18/4/2022.
18?
4/2022.
22.
Again.
Oh.
Release on bail.
He was released on bail. Regular bail, huh?
Sir.
Regular bail or anticipatory bail?
No, irregular.
Regular bail on 18/4/2022. NBW issued on
18/10/2022. 18/10.
नहीं अच्छा 18/4 रे आपको बेल
Bail,
मिला 22 रे और
18/10 रे NBW.
then 500. Okay,
sir.
500. What?
24.
Please, my lord, this is a Belgium. NBW has been issued on 24/12/2022. Earlier, he was on bail 17/8/2011.
17/8 bail, हाँ? ठीक है. NBW के पहला?
24/12/2022.
FIR is
That is running page.
2000 ଦେଲେ ବି ତାଙ୍କର କିଛି ଦୁଃଖ ହବନି।
2011
My lord.
1000 ना?
ଏଇଥିପାଇଁ।
Because 2011.
My lord.
1000.
My lord.
1000.
ଏଇଥିପାଇଁ।
Yes.
25.
My lord, here I am praying for quashing of the proceeding. My lord, the parties have settled the dispute. They are on online. If your lordship permits, the informant can come online.
Where is the informant?
My lord, they have to allow him. Yes.
Yes, this
He
is Samapta Kumar Mohan.
Mr. Nanda is the informant, and Mr. Samapta Mahanti is one of the petitioner, and Mr. Dushman Saw is another petitioner.
What is the offense?
My lord, offense is, my lord, 147, 148, 149, 294, 3.
Writing and all. Yes, Mr. Maharaj. Huh? What?
Both have become lawyers in now this democracy, and so is Anglia.
Who the complainant as well as informant as well as the
Principal.
Huh?
The petitioner.
Oh, he's
principal.
While as a student they were.
As a student, they had done that mistake.
You are telling all these things not to pay the cost or what?
Whatever your lordship directs, I am ready to it.
Very young.
They are in his favor, he will pay.
Yes, yes.
As my senior.
Yes.
As my senior says.
Very good. The petitioner has filed this petition seeking indulgence of this court under 482 CRPC for quashing the entire proceeding on the ground that the petitioner, the informant, and the accused, the petitioners, have settled their dispute out of the court. The petitioners are FIR under section. Page 147 was registered, and accordingly they were charge sheeted also. The informant is the principal of the college where the accused MS Law College, where the accused persons were the student at the time of incident. At present, the petitioners are now practicing lawyers. Therefore, the principal of the college, out of grace, has agreed to settle the dispute.
Yes.
And both the parties are present in the court, and the petitioners being the petitioner being the lawyers at present and the student of a college where they involved in this case led to filing of the FIR by the principal and the learned principal of the college now has shown his grace to pardon these petitioners. It would be appropriate that the petitioners will give a written apology to the principal of the college and submit the written apology in the in person to the principal in the college and render apology, unconditional apology with unconditional apology, report to the court by tomorrow and leave the matter at 2 o'clock tomorrow. Go and write apology, handwriting apology, go to the principal.
They have done it already.
No, go to the principal, touch his feet, say sorry and come and inform.
Sorry, कोई जाने पड़े दीजिए.
Your lordship may call it.
Tomorrow 2 o'clock I'll pass it.
Yes.
You inform that they have gone.
Yes, yes.
And the learned principal, he was your teacher and you behave like this, so therefore you should go and touch his feet.
Yes, yes.
Yes,
Tomorrow at 2 o'clock.
2 o'clock.
26.
Mr. Mohanty,
Yes, sir.
the
Sir.
principal.
Sir,
SK Nanda.
Mr.
Sir,
Nando,
namaskar, sir.
they will go to your college tomorrow to today or tomorrow morning or today. They'll seek apology, treat them as a lawyer and excuse them.
Already they have sought the apology.
Yes, my lord.
It's all right, but by the court order they are going today to you.
Acha, okay, sir. Okay,
One
sir.
is there, other will go.
Other will.
One is there with.
The other
Okay.
will also go.
Yes, other will.
Tomorrow by
and take
11 a.m. they will be here with me.
Yes, 11 a.m. tomorrow.
Oh, bless you.
And inform me at 2 o'clock. Yes.
Yes, sir. Tomorrow 2 o'clock.
2 o'clock. Yes.
Oh, bless you.
Next.
26.
May I lordship? May I lordship, Belgium matter. NW issue 16 April 2019. Belgium matter, my lord.
Bail, when you have got the bail?
My lordship.
When you got the bail, ma'am?
Bail hitla 13 October 2011.
13 October 2011. FIR is 2011. Oh. Where is the order? Order of
16 April
16/4
April 19.
19 is the order granting money for issuance of NBW. 1,000?
500.
500?
Yes, sir.
500. Okay.
27.
May I please, lords. Section 138 of NI Act, my lord. NBW issued on 28/10/2022. Lords, we can see page 10, page 7, my lord. 10,05,500, my lord.
10,05,500.
Yes, my lord.
Summons were issued to you? You didn't go?
Yes, ma'am.
Will surrender within 15 days?
February 26 on or before.
On or before February 26, each petitioner will surrender. 1,000? 10 lakh?
500.
10 lakh? Check. Okay, 500. Okay.
Okay. Don't stay, sir.
28.
Dispose of
28.
9.
The petitioner seeks to challenge, my lord, the cognizance taken against them under section 498, section 4 of the Dowry Act, and 307. my lord.
Yes.
Lord, it arises out of a complaint case. my lord.
Yes.
So, Lordship, may kindly have a glance at Annexure 1 is 16, my lord. That is the complaint petition that has been treated as FIR.
Yes, I'm on that. Which paragraph?
16, my lord.
Yes. That is at
That
the time
due
of.
to non-fulfillment of illegal demand of the accused persons, that
Where are you reading, sir?
Lord, page 16,
Duty. Yes, I got it.
paragraph B. my lord.
Yes. Due to non-fulfillment.
The accused persons, they tortured the complainant both mentally. I am for the father and mother. my lord.
Okay.
I am not for the husband. my lord. That due to non-fulfillment of illegal demand of the accused persons, they tortured the complainant both mentally and physically, assaulted by means of iron rod, even if they didn't provide for other basic amenity to her many times. The accused didn't, number one, didn't allow her to his bedroom and close inside the door from inside house, for which the complainant spent all night.
Yes.
That the accused number one in connivance with other.
Accused number one
accused
must be the husband.
husband. When the complainant sleep in night, the accused number one closed the nose and mouth of the complainant with an oblique motive to kill him in life. So your lordship will see that there is not a word of attempt to murder as against the father and the mother. Then the charge sheet has been filed. But strangely enough, and after the case was lost, my lord, she refused to be medically examined. And charge sheet, after the charge sheet is filed, my lord, we find that
307 against the in-laws also.
yes.
Yes, Mr.
I
Mohan.
have made the informant a party, my lord.
Yes.
What do you see in so far as this accused person being the mother-in-law and father-in-law, there is no allegation in the complaint. And in the charge sheet, where have you got those things?
38 page.
Page 38, huh? Let us see.
Page 38.
38, yes. Come to 38. Please read it.
Minus. On receipt of the complaint petition by the Vansis case number 6477 of 2022 from the Honorable Court of SDGM and BBSR, in which complaint petitioner Devakanya Mishra, daughter of so and so, and
during the marriage, read from here. During the marriage, all
marriage,
demanded of articles such as so
demanded cash of rupees 3 lakhs and
financially affluent, and after
her marriage in her in-laws house, members are demanded 5 lakhs of rupees from her parental house, on demanding that they return torture her both physically and mentally to the complainant. They did not provide food as well as they did not allow to sleep in the bedroom. The accused husband and his family members are assaulted her, demanding more dowry with an intention to kill her in her life. On 30th June 2022, accused husband Satya Sundar Nanda demanded more dowry from the complainant's parental house, for which both the husband and wife quarreled with each other. For that silly matter, the accused husband Satya Sundar forcibly pulled the complainant inside her bedroom and closed the door. Then he assaulted her and became furious. The accused husband Satya Sundar forcibly do unnatural sex with the complainant by instead.
In fact,
that's true, my lord. This is a peculiar case. Otherwise, I would not.
because looking into the age and the allegation, it is a family dispute. So there may be some, we can work out something. Because that is the reason I am giving indulgence.
Notice she is not staying with.
Notice to the opposite party number 2. In the meanwhile, till the next date of hearing, the proceeding before the court below is said qua the present petitioner in so far as the offence under section 307 is concerned.
Obliged.
30 concerned. Returnable within 1 week.
2 weeks, they don't. For even if only I would have.
Make it 15. 15. And requisites to be filed during the course of the day.
By tomorrow.
By tomorrow. 29. देखो तो आयोग तो फाइल कर दी चार्ज शीट तो और किछ कर पे
just 161 statement
very routine thing, very unfortunate thing that the parents are being involved because of the dispute between the wife and husband. Old parents are being dragged into this issue.
Naturally,
they've done everything for the son. They get married, the son, and everything. They want to see good family life of the son, and even then they are involved. General allegations. Very unfortunate.
At the time of bail, so that those 2 persons, independent witness cited, and there 161 statements were given, my lord. After we received the 161 statement, they came of their voluntarily of their own accord and made that police has never asked us any question, nor we have gone to the police station. How come our statement is that? Then this filed an affidavit here stating the same. Those things I am not asking your lordship to go into it, because your lordship will not delve into the merit of the matter.
Let us see if anything can be done.
Yes, sir.
Yes.
29.
29. This was 30, huh? 29, okay.
It's a Belgium case, my lord.
Yes. FIR, when you got the bail?
But I have no instruction, my lord. During the trial stage, my lord, the date fixed to 25/11/2016, my lord. The conducting counsel.
When you got the bail? You are on bail, na?
My lord.
You are on bail.
My lord.
Where is the FIR? Nothing. You have not filed anything. That is the problem.
FIR kitchen
2012.
323, 294, 506, 3 HST.
1000.
30, may I please, your lordships?
Yes.
30, your lordships, I am appearing on behalf of CBI.
Yes. Yes. What is this case, Mr. Naik?
Your lordships may kindly come to.
Yes.
This is CRLMC 2909, your lordships.
Yes.
Your lordships, we are aggrieved by the order of the lower court where we had asked for voice sample of the accused, your lordships. Your lordship may kindly come to.
That is annexure 2.
That is annexure 2, your lordships. Page 58 to page 67.
Yes. Which part you want me to read?
Your lordship may kindly come to. In fact, your lordships should start with annexure 5. Your lordships may start with the arguments on behalf of the counsel, Mr. Tanvir Ahmed, which is in page 61, your lordships.
61.
Yes.
Okay. Read it.
Mr. Tanvir Ahmed, learned, should I read it, your lordships?
No. This is item 30, na? 30. Huh? Where is the annexure? This you are reading second item? Referring to second item?
No, your lordship, I'm reading the first item first. 2022, 2909 of 2022. Both are tagged, your lordships.
No, that is second item. Sorry. Okay.
Yes, second item.
That is second item. Yes. 61, huh?
61. Mr. Tanvir Ahmed being learned senior counsel being assisted by.
1 minute. Yes. I'm so sorry. Yes. Mr. Tanvir Ahmed. Right.
Yes. Mr. Tanvir Ahmed, learned senior counsel being assisted by Jaideep Pal, learned counsel for the accused Charchit Mishra, contended that in the earlier occasion on 10/8/2022, the prosecution has filed similar applications seeking permission of the court to collect the voice sample of the accused persons and their police remand. This court, through a recent order, rejected the prayer made by the prosecution due to want of any valid or convincing materials about the recording of the conversation of the accused persons through legal process. Now, my respectful submission before the Honorable Court is that, your lordships, first, it was rejected, which is annexure 4. After it was rejected, your lordships, again CBI filed a petition in which the ground was taken that, if your lordships will come to the penultimate paragraph, secondly, it was contended that Section 5, Clause 2 of the Indian Telegraph Act.
Which page you are reading?
Same page 61, your lordships.
Okay. Okay. Secondly, it was contended that Section 5(2) of the Indian Telegraph Act permits the interpretation of the message in the accordance with the provisions that yes. Mere permission obtained under Section 5 of Indian Telegraph Act and rules so is of no help unless the order in question is placed before the review committee and accepted by it. In the earlier occasion, the prosecution did not file a copy of the necessary order under yes. What do you want to say?
That whether the said order was accepted by the review committee or not, in the absence of the same order issued by the Home Ministry, is inoperative. Thereby, the interception of the mobile phones of the accused persons is per se illegal from its inception, and same cannot be utilized for any purpose. And a reference has to be given to one case called Jatinder Pal Singh, your lordships.
Right.
I'm giving you a copy of that judgment, your lordships. I'll come to the judgment. I have a copy of that judgment, which was referred to by my learned senior, Mr. Tanvir Ahmed Mir, in the lower court. Now, your lordships may come to page 6 below paragraph 5.
Page?
Next page, your lordships, page 63.
Yes, 63. Right. Yes.
Page 63, paragraph 5. Admittedly, earlier on 10/8/2022, the prosecution has filed an application seeking permission of this court to collect the voice samples of the accused for its comparison with the voice of the accused persons recorded through interception prior to the initiation of the case. This court, having heard the learned counsel for the parties, rejected the prayer of the prosecution, video order dated 10/8/2022. Now, subsequent application has been filed by the prosecution with same prayer for the collection of the voice sample such and such. Since the earlier order was passed in the absence of any document, subsequent application can be considered if the prosecution could file necessary orders passed by the competent authorities. Now he's saying that a direction for the collection of voice samples of the accused in a matter is not a matter of course, but the same can only be granted in exceptional cases. Now, your lordships, page 65 below, last 3 lines. When the review committee is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the directions or order for destructions of the copies of the intercepted message. In view of the above provisions, it is very clear that any order passed under 5(2). Your lordship is not audible. Sorry? I'll come to that, your lordships. Your lordship, this stage, your lordships, the stage is the collection of evidence here. This is not a stage of charge, or this is not a stage of the trial, your lordships. This stage is for the collection of the evidence. Now, the first question is that whether the magistrate has the power to direct the voice sample collection on number 1. Number 2, under which provision of the CRPC the magistrate can do, and whether it can be done under exceptional circumstances or not. Now, lordship, there is a direct judgment of the Honorable Supreme Court, which I want to cite, your lordships. The judgment is Ritesh Sinha versus State of UP. Lordship, may kindly come to the judgment for a moment.
Yes. Which paragraph?
I'll come to it, your lordships. Manish, kindly give a copy to Sori sir also.
Yes, I got it, Mr. Naik. You just tell me the paragraph.
Lordship, this Ritesh Sinha's judgment, your lordships, 2 things came.
Yes.
There was a first, it was listed before division bench.
One minute.
Please wait. What happened in this case? My friend is employing the legality or improvement so for the item number 2 is concerned in the cause list. The case was tagged with that. So for the item number 1 is concerned, sub item number 1. In that case, notices were not sought to
Pleadings are complete, your lordships. Yes. Your lordship, may kindly come to Ritesh Sinha's judgment.
Issued so far. He suggests that let notice go to them, and thereafter both the matters can be heard together.
In respect, your lordship, that is on sanction, your lordship, that can be taken some other time. This matter, pleadings are completed.
At whose instance this matter were tagged?
Your lordship, there is a judicial order, your lordships.
So then there must be some relevancy. So insofar as the first item is concerned, let the notice go then.
Your lordship, in the first matter, the issue was only about the sanction. The court has taken cognizance without a valid sanction, in the absence of sanction. Now we have obtained the sanction, it has been filed. That is only for regularization. This is the more important aspect, your lordship, because investigation is pending since 1.5 years.
That is only sanction.
Sanction part only, very small.
What is the sanction now?
We have obtained the sanction, it has been filed also in court, your lordships.
Then
now, your lordships, we will come to Ritesh Sinha's judgment, your lordship.
They have got the sanction.
So your lordship may detach both the matters. Ask any order so far the item number or sub item number 1 is concerned. I have nothing to say on
Your
that.
lordship, in sub item 1, the counsel is present. He has filed Wakalatnama, which is reflected in the cause list. He is present, your lordships. And Saroj Das, the mechanical engineer, who is the public servant, he is only concerned. Rest are private parties. The only issue, Your Lordship, is that Section 19 is quite clear. No court shall take cognizance of an offence under a PC Act under 7, 11, 13, Your Lordships, if there is no valid sanction. Otherwise, ultimately, during the fact end of the trial, the proceedings may be vitiated. In this case, Your Lordships, without sanction, they have taken cognizance. If Your Lordships will come to last page only, it's a very short issue, Your Lordships.
Then the cognizance goes.
Then the cognizance goes, Your Lordships. My only limited prayer is that the matter should be remanded back. Good minute, sir. Good minute, sir.
CBI has challenged the cognizance order. One of the accused was a public servant by then, and in absence of any valid sanction, cognizance was taken. So it is bad in law. Accordingly, the CBI filed to set aside the cognizance order and take fresh cognizance. So far that matter is concerned, I am no a concern, or I am not either to say this side or that side. That is the accused.
And these matter, Lordship, readings are
Public
complete.
servant, you will say. He has not yet entered appearance, against whom the order has been passed, and my friend has challenged it. So he is the right party to be heard. So I suggested that both the matters be detached. It has no.
It has to be detached because see, this is regarding only the voice sample issue, and that is regarding the sanction qua that Soros whoever it
Yes,
is.
Your Lordship.
Whoever it
So
is.
far the voice taking sample issue is concerned, Your Lordship may fix a particular date. Mr. Hon'Ble was arguing the case.
Okay.
I will inform him and you will.
Yes, Mr. Naik. Then
Your Lordship, there is a junior counsel, sir is a senior advocate, sir can argue.
that's in neither you nor me can comment on that.
Then Your Lordship may fix a short date because Your Lordship, this matter is pending since 1.5 years. It needs to be disposed of.
Matters detag, and in so far as the first item is concerned, issue notice to the opposite parties, returnable within 2 weeks. Hence, you file requisites. In so far as item 1 is concerned,
Yes, sir.
and detag in so far as this item number 2 is concerned, least on. When do you want, sir? 13th? No, let it be 16th. 16th?
Your Lordship, any date after 16th, Your Lordship, any date.
After. You tell me the date.
May I say one thing, my lord?
Yes.
Let it be 23rd, it is more convenient to Mr. Hon'Ble.
23rd, he says 23rd will do. Mr.
Whatever
Naik?
my Lord senior will.
Yes, 23rd. 20.
Your Lordship's requisite through speed post?
Yes, yes. Requisite should speed post.
Yes, sir.
But by the way, which paragraph you wanted to show? Let me complete the sentences to be complete. Let us understand what to know. Because
Your
there is
Lordship's-
contrary judgment also. That is the reason. I'm just
Lordship, Ritesh Sinha's judgment, operating part of Your Lordship's is in paragraph 16 and 17. It
let
says
us complete this sentence, what it says. Yes. Let
It
us
says only, Your Lordship, two things. A magistrate can direct the collection of the voice sample. There is no law under the CRPC, Your Lordships. Therefore, till the time any law is made by the CRPC, the Supreme Court exercised its powers under Article 142 and said and gave that power to the magistrate that you can direct for the collection of voice samples, number one. Number two, the Supreme Court is saying that collection per se would not be violative of Article 20, Clause 3 because you are asking for a voice sample. After it is compared, we can show that whether he is an accused or not. Therefore, the moment we ask somebody that you please give your voice samples, that is not self-incriminatory or that is not violative of 23. It goes to the CFSL. After it is compared, if it comes that the voice samples are matched, then he becomes an accused. So at the time of the collection, it is not violative. And the Supreme Court nowhere says.
He did not hampering the right to silence.
Right to?
Right to silence.
That issue, Your Lordship, has been dealt by this judgment, 3 bench.
There are contrary judgments also. Let us see on that day. The judgment is there, but there are contrary judgments. Right to silence is also a valuable right for an accused.
Oblige, Your Lordship.
We'll see that day. 23rd.
Lordship, a free copy of the order may be provided to.
A free copy of the order.
31. May I please connect? Notice was returned on insufficient manner. Notice was returned from opposite manner.
What is this, sir? This is the
Question of cognizance.
oh.
Notice issued will be due to insufficient address, so that has been returned.
Wait, you are you giving a fresh set of address or same address?
The father's name of opposite was wrong manner and for it to correction. The name of father and thereafter the notice on it notice may be used manner.
You take Dasti then, sir. Take Dasti notice and share. Will postal. Postal.
For to correct the name of father of a opposite man of
Petitioner submits that in pursuance to the order dated 3/1/2024 of this court, a notice could not be served due to insufficient address of opposite party number 2. He furnishes fresh address today. Fresh address. Let the notice be served on the rest opposite party number 2. Returnable on 28. 28.
32.
In the earlier matter, is there any stay? Earlier matter, is there any stay? Let's see, 32, 31, 31, no? 31, let's see, is there any entry model? Is there an entry model? There is no entry model? No, okay. Okay, it's all right. 32, huh?
May I please, Lord? Lord, this irrelevancy related to the release of the vehicle implicated in the NDPS Act. And here in this case, Lord, present petitioner's vehicle is the not offending vehicle, Lord.
457.
Yes, Lord.
Yes.
Here the petitioner's vehicle is not offending vehicle, Lord. And it is alleged that escort,
vehicle.
Lord. Yes,
Escort
Lord.
vehicle.
Escort vehicle, Lord.
What is the condition imposed? You are an accused? The owner is an accused?
Yes, owner is an accused, Lord. Rajesh Adkatia, and his role played that
You were
he is
giving escort in your own bike?
vehicle, Lord.
Bike,
Yes.
bike or what?
That is car, Lord.
Car.
Alto car.
This is the allegation. You become apprehended by the police.
Yes, Lord. On the same.
You are following the offending vehicle or you are going ahead of?
Ahead of, Lord.
Ahead of.
Yes, Lord.
You were apprehended first, thereafter the offending vehicle? Nothing is seized from your vehicle?
Nothing has been seized from the also this vehicle, Lord.
Let us see the fifth order.
That is page 7, Lord.
Yes, read it.
Page 7. Last, they are transporting the same by escorting the vehicle with one Maruti Suzuki Alto bearing number OD02P1044. And mirror, that is page 7, last 7 line, Lord.
Okay.
1, 2, 3, 4, 5, 6, 7,
Okay,
8, 9, 10, 11.
Now, read the order.
Order, Milord. Order, Milord. What happened, Milord? The order is passed by the Honorable SDJ, Milord. SDJ means, Milord, one judgment, our High Court judgment, Milord, has been passed. That is, so many revision petition was considered by Honorable Justice S. Pujari, and I also argued that matter, Milord. In that order, Milord, in paragraph 6, I am just applying it also. That only the prosecution or investigation agency will file for release of the vehicle, Milord. And subsequently, the division bench order also passed with following SO.
Read it. Don't say in abstract.
Milord, sorry, Milord, I have not the copy, Milord. I have just not extra copy. After 2 o'clock, Milord. Try.
What is the proposition you want to?
Milord.
By this, what do you want to say?
Milord, I have no extra copy, just I supplied to court, Milord. That's why I am unable to read, Milord. Praying for
But
two.
what do you want to say? You tell me. You might have read.
For release of the vehicle, Milord. This is
I
the.
understand it.
Milord.
What is the judgment? In what way you will help?
Yes, Milord. That judgment is not help to me, Milord, because they relying the judgment, Milord.
They say that it is only the prosecuting agency will move.
Yes, yes. And we have no scope.
And by history of notification of gadget notification and all. This judgment which is being relied by the trial court, saying that only the prosecuting agency can maintain the application is bad in law. That's
Yes,
what you
my
want
lord.
to
That
say.
is my prayer, my lord.
Long and short is
Yes, yes.
none of these things are you placed on record. This is one part.
Yes.
Second part is, if that is the case, then I'll have to set aside and send it back to the trial court saying that let the application be maintainable and decide on the basis of SOP. And
That is
on the
enough for
guidelines.
me, my lord. Seta hale be hejibo.
Then you make out a case.
Agya.
Kisi file kare
Nahi, khali seta.
file kar de 482.
Na, na. Seta mo ye
Yeah,
kali.
you are such a senior counsel.
No, my lord. Only praying for that observation, my lord. I will move there, my lord.
Without there
Only-
being
only-
anything on record, I'll make observation like this. There is no pleading, there is no document, there is nothing. You show me single word here in the entire petition.
Yes, my lord. Next Monday, I file all the.
You
things.
file a consolidated file so that it will help others also.
Yes, yes, my lord. Yes.
Many cases can be solved.
Yes, my lord.
I can pass a better order so that it can help others.
Again.
And
the
it is
seta-
expected from you like senior.
Yes, yes, my lord. Nahi, seta pending thai ki debi na.
Huh?
Praying for pending this application.
No, I'm not disposing it up.
Yes, yes, my lord.
I'm not disposing. What you do is you file a consolidated
Yes, my
petition
lord. Yes.
and bringing all this record and
Yes, my
sequence of event, when the amendment has taken place, when gazette notification, when the SOP was passed, when that judgment is passed, everything I can take into consideration, set aside it and send it back to the trial court
Yes, yes, my lord.
to decide on its own merit.
Again.
So this stumbling block of this judgment will be taken care of.
Again.
Go and do it and come.
Oh, Sombar dina, my lord. Pray-
No, Monday.
Monday. In between, I have filed the amendment petition. also.
I believe you will do it
Obliged.
with all documents.
Yes, my lord.
Max are already compromised, my lord.
Yes.
And compromise affidavit, my lord, at flag C,
Taxi. What is the offense?
307.
Yes. I have passed some order.
My lord, my
12/1/2024. Let us see. Mrs. Saul and counsel for the petitioner party settle with the dispute and so on the petitioner, the co-accused person have received simple injury.
My lord.
As per the medical documents 307. Since they now settle the dispute. Yes.
All the parties present before our lordships.
Simply. Because
My lord. And my lord, the amendment of cause title that may be accepted, that is flag
Acha, you have filed on behalf of only one person.
one person.
The counsel for the the counsel for the petitioners files the amended memo parties whereby he intend to include Wakalatnama on behalf of
Already.
them you have?
Already filed.
He intend to make the co-accused. How many co-accused?
Two.
Two co-accused as co-petitioner in this petition. The amended memo party is taken on record. He has full stop. He has already filed the Wakalatnama on behalf of the co-petitioner. Newly added co-petitioner. Okay.
Also consolidated cost title already filed.
Amended court of consolidated court. Full stop. And the opposite party number 2 wide order dated 12/1/2024 of this court. This matter was taken up for hearing on 12/1/2024 and the following order was passed. Para 2 following order was passed. Okay. First, the in pursuance to the aforementioned order, the parties have now filed the joint affidavit, consolidated affidavit, which is at flag C. Flag C. Full stop. They have reiterated the fact that they have settled their disputes. Both the parties are present in the court, and they have filed their respective attested copy of respective Aadhaar card to establish their identity. The counsel for the parties have identified their clients, those who are present in the court. Mr. Ragada, appearing for the state, submits that in view of the fact that the medical report indicates that the injury sustained by the informant is simple in nature. There is no impediment in quashing the FI. Next, accordingly, so and so is quashed.
Obliged.
34, my lord, on behalf of
Mr.
Mr.
Ragada,
Suryakant Dwivedi, my
these
lord.
kind of quashing matters,
My lord,
we should impose little cost also.
my lord, little better. When the injured is there, my lord, for that you have.
Simply you are escaping. You pay some cost. You have beaten someone. Use the court.
Otherwise, they go to the court.
You have
and they spend much more money.
use the time of the trial court as well as this court.
You actually had power, but it otherwise hamper our fees.
You cut a little bit from there.
Because I'm ready to pay.
As
It
your
will
lordship.
go to you only eventually. How many accused? Three.
Three.
So 3,000.
3,000.
My lord.
1,000 each.
I could buy a welfare fund.
Bar Association Welfare.
Obliged, ma'am.
We will enrich the association for fund.
My lord, 34, on behalf of Mr. Suryakant Dwivedi, my lord, kindly taken up next week.
Urgent. Next week we are not sure, but urgent.
35. 35 on behalf of Mr. H.N. Mahapatra. Kindly today I have filed a consolidated petition, my lord, and also a copy to government. Kindly taken up one way actor, my lord.
Urgent.
I have objection, my lord. I am for the informant. They are enjoying this interim order since.
Oh, there is an interim order. 35.
My lord, my lord.
35.
My lord.
35.
35. Let us see. Where is the
Last
interim?
order, my lord, kind of glance. 28/8/2023. No further adjournment will be given. Lord, one accused person before your ownership, before your lordship, one petitioner. 4 accused person, they are enjoying also.
Considered petition as filed.
What you may file, you can't take the court order like this.
No.
This is the order dated which you are showing it.
28/8.
It is made clear that no further adjournment shall be granted. Interim order passed earlier shall continue till the next day.
What happened, my lord, kind of glance to the prayer also, not maintainable.
That is a part. How to deal with this order? I can't disregard the order of a coordinate bench. I'll vacate the stay and you proceed what to do.
Taken up tomorrow, my lord. I have a file today, considered petition, and
taken up.
Now, why are you taking court order like this so simply? And this order
And
is up
pass over, my lord.
August,
Pass over, I have,
28th August to 2023. It says that no further adjournment will be given.
Okay, my lord, pass over. I'll
And it
argue
will
with my
continue
senior.
next date of hearing. And next date of hearing, whether it is continued,
Yes, my lord.
it is continued. Why have you not opposed that day?
That day I also complained, they are taking other pleas.
Our Mahapadal Council appearing for the informant has no serious objections. You have no serious objection. Today you are making serious objection. That is why the interim order was continued. You diluted the earlier order.
Next week, ask my lord.
Later, pass over, my lord, 2 o'clock. They are enjoying the interim order.
I'll impose cost for adjournment. You can't escape like this.
Okay,
See,
my
last
lord.
order, just see.
Only pass over. I have to argue with my
I'll pass
senior.
it
lord.
over.
Yes, ma'am.
I'll pass it.
36.
Item 36 can take no 1 week after me.
Adjourned.
Item 39 also.
39 also.
Ma'am.
Anirudh Das. Chalo, 39 also.
37.
Oblige.
This one, my lord, order of cognizance is challenged, my lord. Annexure to page 17, my lord. Annexure to page 17, my lord.
Okay.
I'm kindly be disposed of the writ petition with the liberty to raise all the points, my lord, at the time of framing of charge, my lord.
That's what you want.
My lord.
Okay. Good. So the petitioner has challenged the order dated 11/5/2017, whereby the related court below has taken cognizance of offences under section page 17 page 17 Legal counsel for the petitioner submits that he may be given liberty to raise all these points, all the points, all the points available to him under law at the time of framing of charges. The petition is dismissed as withdrawn with liberty as spread. Disposed.
38.
May I please, your lordship. Sir, here in this case, my limited prayer is to direct the trial court to dispose of the ST case number 240 of 2012 within a fixed period. Earlier, this honorable court in BLAPL number 5948 of 2009 and CLMC number 253 of 2020 directed the trial court to dispose of the case within 6 months.
Which order?
Your
See,
lordship,
this is a very unique petition you have filed. You have filed a petition without any annexure. This is the first time I have seen no order, no FIR, no nothing. Only a simple petition like a school children giving application for leave. Beg to state that, kindly grant me 1 day leave. 482 petition. Where is the order? Where is it? There is not a single annexure.
no, I have not challenged any order, your lordship.
That's right, but you are relying upon some order. Where is the
No, only my prayer is to direct the trial
That's
court
right.
to dispose of the
You
ST
have
case.
said that some orders were passed by this court.
Yes, your lordship.
Where is that order?
No, I have not annexed that.
Then I will imagine everything.
In certificate, I have given the case number, your lordship.
At least you file those orders. What is this? There is no FIR. What is this case? ST case. What is this?
They also not solved the copy also.
The copy already solved, your
See,
lordship.
don't take High Court proceedings so lightly. If anywhere else this would have happened, at least a 50,000 rupees cost. At least where I have practiced, 50,000 rupees cost would have been imposed in this case. We have suffered this kind of this thing. What is this petition? ST case. What is this ST case? What is the offense?
Lordship, I have
Where is
said-
the FIR? Where is the charge sheet? Where is the order relied upon? What is the stage of the trial? Nothing. Only a 2-page application and 482. Very sorry state of affairs, sir. This is not done. what is this order? After hearing the learned counsel for the petitioner, the court would like to know as to what petition was filed in the court below. Just see the order of last order dated 12/7/2003. The earlier coordinate bench has also indicated you to place on record something. Just see the order. 12/7/2023. My Lord Justice Sankar Mishra has passed this order. You have not done anything. After hearing the learned counsel for the petitioner, this court would like to know as to what petition was filed in the court below. Learned counsel for the petitioner is directed to produce the copy of the same for perusal of the court. That also you have not filed. Shall I dismiss it with cost or shall you file something?
No, I will file your lordship.
When?
Next week, lordship.
Next week means specially for you, time has to be taken out.
No.
You are wasting the court's time, sir. Don't do that, please. Put it up in the mark. Last time the court has also indicated you.
Yes, sir, lordship.
That also you have not done. How can you be so casual? Do it properly. It's after all the High Court. If you don't respect the High Court proceeding, who else will be? Anyway, do it.
Here the present petitioner is the owner of a pan masala unit mallet, and he is also having the due license given by the authorities, and also the all aspect has been taken care of. And but surprisingly, the unit was verified, checked, and inquired into, and some illegal
457.
It has been found. And thereafter, my property, that means the pan masala, the machines, and cash of 1,50,000 was seized. I approached the court below, giving all details that I am the particular person having all sort of documents with me, and I am authorized under law to run the unit. And accordingly, taking care of the court below has allowed rejected my application by the court SDM. It was taken before the Court of Sessions. In the revision, the revision has been allowed, thereby directing to release the machines, the gutka and everything, the pan masala and the other aspect, the products matter. But the court has said 1,50,000, I have failed to give a proper explanation regarding that one, and he is rejected. My humble submission, when 1,50,000 is the sale proceed, it was very much available, and all other aspect has been taken care of by the Land Provisional Court. He has
only you are agreed by that one non-release of 1.5 lakh, 50 lakh. What is the reasoning given by the trial court? Let us see.
Let me see page
19.
Yes.
IB.
Yes. IB last one. Last one.
Failed to show any valuable rights over the seized rupees 1,50,000.
1,50,000 was
देखिए बनाने किसी
देखिए कोड जो जिंसो थिला प्रोडक्ट थिला मशीन थिला जिंसो आसला सेल पोजिट थिला
सेट टू सीज एची सब
आगे सब उडा सीट पूरा and he has allowed everything.
What is your plea? You are not there, or it is not my premises?
No.
What is your plea?
Admittedly, it was my premises. Admittedly, I taking a license
from your premises.
Yes. See, but so many chondi. The court has admitted.
The London court below release all the things, my lord. The materials says.
No, if he takes a plea that not my premises, it is seized, then I can understand.
From the
if he that it's my premises, it is seized from me.
He's on. They are unable to, my lord, show the valuable rights regarding the 1,50,000.
Rights? How will you show?
How they?
Is a material or a purchase and give a invoice. It is his money. He's there. What is this?
How they have managed after this money kept their manner that they have not shown anything. For that reason,
pan masala businessman, from business he might have bought it.
Where from it? Online received नहीं देखे पता.
कहते indemnity दियो तो किसी ने किम दे दे.
वो ठीक है इसमें अलग में से.
कौन indemnity कौन देवे?
Property security दे दी.
Property security दे.
आगे.
And council
1,50,000 আছে মানে में से 2 lakhs of property.
2 lakhs property security
आगे
जान तो
ठीक है अच्छा.
Property security देवे ना indemnity bond देवे.
हाँ yes.
दीदा दे दी.
हाँ ठीक है ठीक है.
Petitioner challenged the order dated. What is this order?
Malad में से
5/5/2023.
Annex 2 page 13.
Passed by the Land Court of
First Additional Session Judge, Berhampur, in criminal division.
Also, whereby his application under section 457 TRPC has been partly allowed. Partly allowed. The Learned Trial Court has released the item bearing number, serial number 137 to 13, which are nicotine and consumable items, and consumable items, whereas the gas recovered from the seized from the premises, from his premises, to the tune of 1,50,000 was declined to be released to him. Full stop. The petitioner is aggrieved by the order to the extent that of non-release of 1,50,000 rupees cash from him. Full stop. The present petition is partly allowed, directing the trial court to release 1,50,000 rupees cash, subject to the petitioner furnishing a property surety of 2 lakh rupees and furnishing a indemnity bond to the like amount. To the like amount. Okay? Petition is allowed.
My lord, I said petition is partly allowed. My lord, I said allowed because
petition
that
is
the only
allowed.
prayer. Yes, because that is the only prayer.
Petition is allowed.
Oblige, ma'am.
41. On behalf of Mr. Chaudhary, kindly add next week.
Criminal lawyer of your stature comes, when he says one word, we have to be careful. The last words are very dangerous words. And you have to see what is the consequence.
Yes, I do consider I am obliged for that. But had there been no practice of this honorable court in this field, matter would have been something different. Matter has also vast experience in this field also. So our word and Matter's word.
No. Last word slowly when the senior lawyer of your stature says, that carries more weight. It has a larger consequence.
On behalf of Mr. Chaudhary, kindly adjourn next week.
Adjourn. Yes. 42.
May I please the lordship, my lord?
Yes.
In this case, my lord, I have prayed for the quashing of the criminal proceeding on the ground that on the same set of evidence and witnesses, the co-accused person got acquittal, my lord.
You absconded, what to do?
Now I have surrender and release on bail, my lord.
Face it.
With on the same set of evidence, my lord.
Maybe, but
the honorable.
I'll expedite it.
Yes. No, my lord, I have a decision, my lord. The recent decision of the Honorable Supreme Court.
What is the offense?
Offense 395, my lord.
395.
And the eyewitness has not supported the prosecution case. 395 not made out. Vividly discussed in the judgment decision, my lord.
No, everything is all right, but you were absconding, so therefore, why leniency for you? What is the stage of trial?
Trial has not been started so far the petitioner is concerned.
Naturally.
But he is involved with 3 cases and 3
Yes,
cases.
yes. The 42, 43 are also those those co-accused person acquitted. They are
you have a very good tactic. You commit the trial, abscond, and wait till the other accused
ultimately
influence the trial and get an acquittal, then you come and show it.
Then ultimately what will the result, my lord?
Result may be whatever. Why the 482 court will be giving indulgence to a person who is involved in many cases of similar nature?
Yes, those persons who are.
I'll expedite.
Sorry, I'm submitting, man. Those persons who are acquitted, they are also involved in 3 cases, my lord.
Maybe they suffered the trial and they could successfully influence the witnesses.
No, witnesses are same.
The benefit of which you have get.
Those witnesses did not support anything, my lord. 1, 2, 3, 4 are family members. And discussed in the judgment. Kindly have a glance to the, my lord. The London trial court discussed very clearly, man.
If he will file no prejudice member before the trial court, my lord, the same set evidence will be utilized, he will get acquitted.
Why don't you do that?
That is there, madam. If he file petition there, that same set, if the same set evidence is utilized against him, he has no prejudice.
Then that would be yes, that would be kind of a pleading guilty kind of situation.
Jaldi sir, you expect na kare sir.
Bhajanlal case as well as the recent decision of Honorable Supreme Court.
The only test where he succeeds is to meet at this stage, if the 482 court is of the view that the trial is in futility, the judicial time can be saved by quasi.
Yes, sir, this
That
is
is
my
the only,
submission.
only positive thing
Yes, ma'am.
in his favor.
In fact, my lord, his involvement.
We know that he will be acquitted.
My lord.
So
But
then
that
why
I am saying
should we
that
waste the judicial time? That
Yes,
is
sir.
the only
My only submission.
area where
And
I would
if
think
if
of.
you file petition there also, no prejudicial memo, then the same set of evidence will be utilized against him. One day he will be acquitted, my lord.
No, no.
That is the law, my lord. If you will file the petition there, that all the evidences deposed against a co-accused person who has get acquitted, my lord, be utilized against him.
The informant
Yes,
could
no.
not identify the TI parent, my lord. And the also siege articles are not.
In your question, where is TI parent?
He
You were out.
acquitted. How
Same
did
case, my lord. Same case. Those are arrested and this person is absconded, my lord. File this petition. This honorable court has directed to surrender and come again. In the meantime, I have been granted bail, my lord.
Where is that order?
I will give you a copy, madam. This is the bail order. In all cases, madam. This is my copy. I will give you a copy, madam.
What is this? You got the bail.
Bail order, my yes, madam.
Show me the judgment which you have.
Yes, madam. This is Javed Shaukat Ali Qureshi, madam. Versus State of Gujarat.
You give judgment. I'm putting out on Friday, 2nd of February. Just consider the evidence. Anything is there against him. You file all the evidences?
Evidence
Huh?
No.
Evidence file करो.
Yes.
যদি নাহি কিছু বলে will quasi.
Yes, yes.
File you give it to Mr. Ragada.
Yes, yes.
We'll just see the evidence. And if there is nothing,
Yes, yes.
then
I'll give, madam.
we can.
All the three cases, madam. 42
And all the judgment which you are relying upon.
Yes,
you
yes, I'll
give
give,
him.
madam.
He will assist. Not you. If he says quas, then I'll quas.
Today or tomorrow, I will give, madam.
Give it to him.
Yes, yes. 42, 43, same, madam.
Just see what are the evidence.
Madam.
which are there.
Obliged.
If it's a case of no evidence for these accused person, I don't think putting him to trial again is a wastage of judicial time.
No evidence, madam.
Yes.
Obliged.
44.
Yes.
I have seen the passing of cognizance, my lord. Initially, case was registered under section 363, my lord. Now, charge sheet we have filed, my lord, under section 363, 363.
Again, the same question which I put to Mr. Chan. Cognizance is taken on the charge sheet or the FIR. Where is charge sheet?
Charge sheet copy. I have already filed the charge sheet.
Fine, it's not there.
वो charge sheet copy दे दी.
ଆମକୁ ତ କିଛି କପି ଦିଅ ଖାଲି ଏଫଆଇଆର ଦେଇଛ କିଛି ନାହିଁ କପି
Yes, yes, he has filed in a flag B. ଆପଣ ପାଇଛନ୍ତି?
ଆମ ପାଇଁ କିଛି ନାହିଁ ଆମ ପାଇଁ ଖାଲି ପିଟିସନ ଟା ଆଉ ଏଫଆଇଆର ଟା ଅଛି
ସେ record ମାଗନ୍ତୁ. Record ମାଗନ୍ତୁ.
ଏଫଆଇଆର ଦେଇଛ ଆଉ କିଛି ନାହିଁ
Now, what is your case?
Yes, my lord, here initially case was registered one person, my lord, that is 63 against my brother, my lord, my younger brother. That is, my lord, his name is Pintu Biswal, my lord. I am the elder brother of the Pintu Biswal.
Purna Chandra Vishwal. You are Purna Chandra Vishwal.
Here,
Yes.
my lord, now charge sheet was filed, my lord, under section 363, 366, 354, 342.
And 34 also.
354A,
Come on.
And 325.
See the allegation. Let us see. Come.
Allegation at.
What is the allegation?
At page 11, my lord.
Yeah, charge sheet. You read the charge sheet.
Charge sheet I have placed.
Don't read the allegation.
Brief fact, my lord. During investigation, course of maintenance spot visited, witnesses and complainant were examined and their statement under section 161 CRPC has been recorded. Admission registered of school where the missing girl was studying has been seized and left in Jima. On verification, it is found that date of birth is 2005. Investigation reveals that on 24/2022 at about 3 p.m. while the victim Rupa Biswal, daughter of Subhash Biswal, also remained present backside of her body and talked of her mobile phone. At that time, she was received a phone call from unknown person, unknown number, and that person told her that now where you are. But the victim told him that she was at her body. But this time one Pintu, Siva Vishwal, forcibly taken to her and compelled her marriage in goddess Mahisa temple. The accused person had kept the victim with a proper and she has been not allowed to talk her with her family member. Thereafter, on 7/5/2022 night at about 2 a.m., finding the opportunity, she shared her location to her family member, and after receiving her location, location motor, uncle brother of victim proceeded to Gujarat and rescued the victim. The accused person assaulted her mother and maternal uncle. They brought the notice local police. Police rescued her and hand over her garden. On being examined, the victim lady.
Is there any 164 statement?
Only affair is there, nothing else.
You also call for that.
164 statement.
You also call for that.
See, in this case, what had happened is there is a specific allegation against Sibo Mishra.
Love relation with.
He has kidnapped, whatever, kidnapped, that allegations are there. Thereafter, no name, nothing is there. Thereafter, this next sentence starts, the accused persons. And in that accused persons, plural, his elder brother is also booked. Unless
yes,
that girl has said anything in 164 statement that his brother has helped to kidnap or whatever. Allegation is Sibo Vishwal made a phone call that I am in the, where are you? She says that I am in the Bari. Then she comes to the Bari and kidnap her and took her to a temple and married.
Gujarat.
Gujarat and married. If your case is, prosecution case is, the elder brother is accompanied, was there in the marriage or some role is played, how can you bring his elder brother into it?
No, it Pintu Vishwal kidnap korchi bili
yes,
affair ଅଛି.
Pintu is the Sibo Vishwal.
My younger brother.
Younger brother.
So who is Sibo? I don't know.
Sibo is Pintu. He is Purno.
No. Sibo is not Pintu. Pintu Vishwal is
No, Pintu alias Sibo Vishwal.
Yes.
ସେଇଟା ତ ଆମ ପାଖରେ କିଛି ନାହିଁ.
Purno Chandra Vishwal the elder brother. This petition is Purno Chandra Vishwal.
What I heard from your lordship while your lordship was reading, uncle is there. The word use uncle.
But his brother, elder brother, uncle.
Uncle is there.
No, he only says that uncle, they got an opportunity, came out and then went to uncle and said all this.
Pintu alias Siva Vishwal.
I'll get 160 statement. So
the problem is, Mr. Patel, I'll tell you, the problem is you want to want that everything should be quashed without supplying the document. You have a good case, but you don't have document. You have to place this document so that immediately we could have done it. In what way we can help? The prosecutor is completely blank. You don't supply the copy. Then what way? Without hearing prosecutor, I can't quash.
Yes.
Cognizance order ta diyan tau.
No, at page 88.
Nahi kichhe hai.
How will he assist? You file everything in the under memo only. In the main petition, nothing. Adjourn it to for 8th, 9th, whatever. You file everything. Otherwise, how? No. You file a 482 petition and we will supply everything to you. It is your case. You have to substantiate.
No, in course of the
You do it, whatever. You have a good case, therefore I am saying. Otherwise, I would have dismissed it without this thing. And with cost, because you are appearing. You are bar council member and everything, you are teaching all these things to juniors like this.
Honorable member.
Honorable member, therefore cost at least 20,000 cost to be paid to the bar
council. Bar association.
Do it by...
in course of the
do it.
In course of the
8. File 164 statement and all. You have a case. It can be quashed. Yes.
Item 47. Item 47, my lord, withdraw, my lord. I have 47.
Withdraw.
47.
My lord. 2 applications is there, my lord, both are.
There are 2 petitions. Why withdraw?
My lord, already it is filed for. He has already instructed me to withdraw, my lord.
The counsel for the Mr. Shobhakya Kumar Das, the counsel for the petitioner, submits that infractious. Both the petitions are infractious. Therefore, he wants to withdraw. Dismiss as withdrawn. both, 47 রে দুইটা আছে, 4069 and 4071. Yeah, ঠিক আছে। 45.
May I please, Your Lordship?
Copy may be given. Private,
This is private.
private.
My lord, in this criminal miss case, the petitioner challenging the order passed by the learned JMFC Dhamnagar on order dated 3/8/2023. My lord, the fact of the case is that initially
এটা cognizance order?
the protest petition order.
Huh?
Protest petition order.
Okay, protest petition. Okay.
Initially, the FIR was registered under section 341, 294, 323, 320.
You are the informant?
Yes, my lord.
Okay. You are, the protest petition is dismissed?
Dismissed. my lord.
Yes.
Dismissed on the lordship, kindly have a glance. The order, the last.
Yes. After filing this complaint petition, initial statement of the complainant, namely Surendra Kumar Ponda.
The last page of the order, my lord. Last page.
102.
102, my lord.
Nah, reading.
My lord, the learned counsel of the complainant today filed Xerox copy of the receipt of the ornament purchased by the son of the complainant, Devdeep Ponda, on through perusal of the purchase of those purchase receipt. It reveals that the purchase receipt is a forged and tampered document at the name column of the purchase receipt has been intentionally tampered and is filed by the handwriting. Further, seizure has not been made under section 379 of IPC. On consideration of the above material on record, it appears that the version of the complainant is divergent from the narration of the complaint petition. The witness, namely Janmejay Panda and Rajkishore Rana, examined during inquiry under section 202 does not reveals that accused person has committed theft of ornaments from the house of the complainant. Hence, offense under section 379 of IPC is not made out against the accused person. Hence, the protest complaint petition filed by the complainant is rejected, being devoid of merit. Lordship, kindly have a glance. The running page 96, the ornament slips, madam. It is clearly mentioned that the.
What is your case? You tell me orally.
My lord, the case is, your lordship, kindly have a glance on the affair, my lord.
No, you tell me what is the case. I don't understand.
The fact is that, my lord, the complainant son married to one Pratikya Panda, my lord. And after 3 months of marriage, she committed suicide, and her mother-in-law came and other family members of the family, the in-laws family of the son of the complainant came to the house of the complainant and taken entire ornaments, my lord, and broke the almirah and take care entire ornaments and valuable articles.
You are the husband.
I am the father, my lord. I am the complainant, father, my lord.
Father of whom?
Father of the son, the bridegroom, my lord.
Yes, tell me thereafter what happened.
Thereafter, my lord, I have visited several times to the police station. The police did not register my case, my lord. After that, I came to the High Court, this Hon'Ble Court.
What happened to that 306 case?
306 case is, my lord, the father-in-law and mother-in-law have already been released on bail. The trial is proceeded, my lord. And that is continuing now. The trial is continuing.
Here, what do you want then? You want that?
Initially, the affair was registered under section 379, my lord. I have supplied everything, my lord. Your lordship, kindly have a glance. My running page 9, my lord.
9, huh?
9, my lord. The top para, my lord. On 21/4/2020 रे स्वर्णलताଙ୍କ द्वारा दिया जाता
9 is something different here.
9, my lord.
Annexure 1.
Annexure 1. Running page 23, my lord. 23, sir.
23.
3, my lord.
23.
Yes, my lord.
23 is something different.
23 is, my lord, my written allegation. Written affair, my lord.
Yes. 21. 20.
Starts from 21 and 20.
23 you are reading, yes.
21/4/2020, my lord. I am starting from 2020. The first top. The ସ୍ୱର୍ଣ୍ଣଲତାଙ୍କ ଦ୍ୱାରା ଦିଆଯାଇଥିବା ସମସ୍ତ ଜିନିଷ ଥାନା
ସ୍ୱର୍ଣ୍ଣଲତାଙ୍କ ଦ୍ୱାରା
ଦିଆଯାଇଥିବା ସମସ୍ତ ଜିନିଷ ଥାନା ଦ୍ୱାରା ଫେରାଇ ନେବା ପରେ ଆମ ଅଳଙ୍କାର କଥା କୁଆଡେ ଗଲା ପଚାରିବାରୁ ମୋରି ଘରେ ସେ ମହାଶୟ ଓ ସୁରକ୍ଷା ବଳ 29 ବର୍ଷ ପୁରୁଣା ଆଲମିରା ଭାଙ୍ଗି କିଛି ପାଇନଥିଲେ, ଏପରିକି ଏ ଯାଏଁ ବୋହୂକୁ ଦେଇଥିବା ଅଳଙ୍କାର, ରାଣୀହାର, ହୀରାମୋତି ଓ ହାତ ବାହୁଟି ରସିଦ ଥାଇ ଆମେ ପାଉନାହୁଁ। For that, the affair was registered, my lord. The entire ornaments was taken by the accused person. After that, the FIR was initially registered under section 379 of IPC and other offences, my lord. After that, the police has completed investigation and submitted the final form, my lord. And
You
deleting
have
the
added whom, who all are the accused?
accused, my lord, the entire.
Let us see. Who all are the accused?
There are, my lord, 12
Saraswati, Swarnalata.
Swarnalata Sadangi.
Who is she?
Mother-in-law of the.
Mother-in-law of who?
Of the son of the complainant, my lord.
Son of who?
Complainant.
Mother-in-law. Okay.
The second is father-in-law.
Prasanna Sadangi, father.
Father-in-law.
And Akshay Sadangi?
Sister-in-law. And other relatives, my lord, those who came to the.
All of them came to your house.
All of them.
And taken their ornament.
Taken their ornaments along with my ornaments, my lord, which I was purchased and gifted to my daughter-in-law.
It looks like a counter case.
No, my lord. Initially FIR was registered on 2020, my lord.
This
This
FIR
FIR was registered in the year 2023, my lord.
Yes, Mr. Raghuda, you are appearing.
No, my lord, this is a private party.
Private.
But protest petition, it is arising out of
It got
a
served
FIR.
a copy on the
It is
state.
arising out
Yes,
of an
not
FIR.
filed.
Yes, he has to file the copy, serve the copy on the
A
state.
complaint was filed, thereafter a FIR was registered
Madam.
under 156(3). And after investigation, they filed final form without this thing. He files a protest petition, which is now rejected. What is the allegation is there is a 306 case which is pending. He is the father of the husband.
Madam.
And after 30 case was registered, his son's wife died. The family member of the girl who had died, all of them came to their house and taken all the gold ornament and all, including the ornament, their ornament. And they have the receipts of their ornament. So far as the other ornament is concerned, the girl's ornament they have taken, it's all right. 379 will not make out. But if they have taken the ornament of their ornament, where she is filing all the receipts, then 379 is made out. Insofar as those ornaments are concerned.
Notice rightly point out.
So protest petition says that no, you have not
Generally,
issue notice to the opposite party.
and he has also made the
Opposite
state
parties.
party, madam.
And opposite parties. Now the land council for the petitioner states that he would be impleading state as a respondent number 13 in this petition. Petition. So Mr. Raghuda would appear for respondent number 13 once the state is made party. Let the land council for the petitioner file a amended memo parties during the course of the issue notice to the opposite party number 1 to 12. All of them are accused.
Amendment petition by tomorrow, man.
By tomorrow. Okay. Returnable 23, 24. To that extent only. 379 to that extent.
Yes. Deeply obliged.
After lunch. Want to mention, sir? What about the passover matters? All the passover and police have. How much time will you take?
It's fresh, my lords. It's coming for the first time.
Then it's all right.
I apologize for the bulk, my lords. Please don't.
It's little scary.
Don't get intimidated by that, my lord. It's partially, I think, some over enthusiasm on our part.
Maybe sometime what happens is
Also
the
retyping.
thicker is the volume, the smaller is the issue.
I hope as long as there is some merit in
There is no scanning. Yes.
Lordship, I just keep it aside. I'll give a background summary, my lords, and
Yes.
then if only few pages are needed to be shown, my lords.
Hmm.
This is, my lord, the second round before this honorable court, my lord.
Okay.
This arises out of proceedings, my lords, under the PMLA Act. We had come on an earlier occasion, because I'll show that order. And the objection raised by the department was at that stage that this is premature because we have only come against ECIR. Now, my lord's complaint has been filed, etc. So that objection, which I will show, which is noted, my lord, by this honorable court in the earlier round, saying that in any event, it's not fructified in a complaint, that bridge is now crossed. There is now a complaint, my lord, and therefore that is the reason why I'm before this honorable court. Now, lord, just to give background.
Essentially, you're asking for quashing of the entire.
Yes, yes. And the reason for this is, Lord, just 2 or 3 background facts. I'll take for the moment, Lord, what is their case against me. Their case against me is, my lord, that there is some illegal mining for the period, please, those dates are of some significance, 31/7/1990. I'm taking the case against me as it is.
Yes.
31/7/1990 to 31st July 2009.
Yes.
That is what, my lords, as is known in under the PMLA, that is what is the predicate offense or the scheduled offense.
Right.
Not the scheduled offense, but the predicate.
Predicating.
Offense. It's the predicate, not the scheduled. I'm wrong.
Yes.
Now, in that predicate offense, my lords, there is allegation 120B, 13(1)D read with 13(2) PC Act, and my lords, Forest Conservation Act, etc. One very important fact to be noted.
What are you, by the way?
Lords, I am the private individual who is the holder of the mining lease.
Okay.
Or the successor of the holder of the mining lease.
Okay.
And I'm very obliged for that question, my lord, because in the predicate offense, there are 15 accused.
Under the aid of 120B, you have been roped in.
Yes. Now,
right.
who are the first 14 accused in that? Are all the government servants, my lords, who are the allegation is have connived with me to benefit me.
Right.
And I will show even from the current complaint, my lords, at various places they have used the word connivance. That in connivance with me, my lord, they have some benefit has been passed on to me and certain illegal gains on my part.
Right.
Now, for the purpose of this case, my lord, what is the scheduled offense is only 2. One is 120B IPC.
Yes.
And second is section 13 of the Prevention of Corruption Act. All the other offenses in the predicate offense are not scheduled offenses. But interestingly, my lord, now when this case is taken, the complaint is filed, there is no whisper of 1 to 14.
Okay.
1 to 14, my lord, are not even examined. And the case is focused only against me and, my lords, with the aid of section 70, the partnership firm. That was the holder also of the mining lease. I am the one that they say who represented, whether lawfully or unlawfully, that itself another issue, the partnership firm. So, my lords, the current case that is now initiated is first 14 out, with whom, my lords, the connivance is supposed to have taken place, and all the proceeds of crime, my lords, are attributed to me. That's the first thing. Second thing, and what is most interesting, my lord, that's why I mentioned the dates in the beginning. The period of the alleged illegal mining is 1990 to 2009. In the charge sheet in the predicate offense, based on whatever calculation.
What is the check period?
For that period, my lord.
Same check period.
No, yes, because admittedly, I have ceased mining on 31st July 2009, admittedly. So there's no dispute after 2009. Based on whatever their investigation in that, which I can't really press before this court, because I'll tell your lordship, there's another round pending. There is certain assessment according to that FIR or that charge sheet that there is loss cost to the exchequer. Now, lords, 2 streams at this stage. One is, as far as the predicate offense is concerned, we filed discharge rejected, came to this honorable court. This honorable court also rejected. SLP is pending in the Supreme Court. But, my lord, there is a very...
Then ideally you should wait till the SLP.
I am very obliged. But because there is a very important order passed by the Supreme Court. The order of the Supreme Court is, my lords, no coercive measures to be taken against me.
Under that predicating of.
Yes. Now, according to me, my lords, in my respectful, that is why when I came on the earlier occasion, this honorable court observed, listen, you come here too early. What has happened in this case? They are only in...
Show me the, or which page?
Yes.
Supreme Court.
Your lordship, the Supreme Court order, my lord.
What essentially you are trying to say is since
That is one
Supreme Court has passed the order
Yes.
for holding the hands.
Yes, there's no coercive measures, my lord.
Till SLP is
Yes,
disposed of.
yes.
So therefore, ideally,
Yes,
PMLA
239
should await. PMLA should await till that
Yes,
is ideally.
yes.
Where is the order from?
239, my lords, 15th
239.
March 21.
239.
Yes. Notice returnable in 4 weeks. Meanwhile, no coercive steps be taken against the petitioner.
Yes.
Now, my lord, therefore, when I came on the earlier occasion, and perhaps rightly, my lord, this honorable court observed, listen, there are ECIR
Are you on bail on that predicating offense?
Yes, yes, there is no problem as far as that is concerned, my lord. There is no coercive measures being taken against
SLP is arising out of order seeking
discharge in the predicate offense. And on the basis of the judgment in Vijay Madan Lal Chaudhary, which is now become, if I may say so, my lord, it is the constitution or the Bible of PMLA. If I succeed in that and the predicate offense gets wiped out, the law is 100% clear, my lord, this case will go. It will fall. So that is one aspect, my lord. And therefore, my lord, now, of course, they have taken cognizance. There is a date.
At this stage, why should I get into all these things? Actually, volume news. Let it be scanned. What I'll do is I'll issue notice.
Very well.
I will see.
Yes, I am there.
You are there.
Yes.
Yes.
So far, predicate offense is concerned, my lord, that has no bearing with the PML offense.
I'll come to
because by the time the predicate offense was challenged, the initiation of predicate offense was challenged, it was negatived by the Honorable Court, and thereafter it was now pending before the Honorable Supreme Court. SLP is there in respect of predicate offense. But what is the offense under PML Act? That is to be seen now. The PML offense is that the offense is to be initiated only on the basis of the information lodged in the predicate
But in
offense.
the absence of predicating offense, can you
No,
resort to
no.
PMLA?
So only by submission of FIR, by submission of FIR in predicate offense, that is sufficient for.
See, that is
If it is wiped out.
If it is wiped out, means it will take time.
If the court quashes it, then
yes,
what?
that has been settled, matter. Then we have to, that the Honorable Court may say, yes, the trial is over, so far the PML is concerned. Now you please wait till the disposal of the predicate offense. Not that will not proceed with the PMLA case. That means no proceeding under the PMLA Act will continue, all will be started unless the proceeding under predicate offense will be concluded. That is not the case. That is not the law. Now it has been settled that only if the predicate offense, the accused will be acquitted in predicate offense, it will have an effect on the PML Act. So now we are in the state of investigation. Now things that, yes, let me submit.
Yes.
Now, when the investigation was in force by the PML authority, it was challenged.
Now, I am only simply issuing notice on the
But
interim order.
it is not
And
entered
also in the main also.
It is not entertainable. I am satisfying your lordships. It is not entertainable because this particular case, 482 application was there. And also, in that event, my lord, I am submitting a decision.
And what was that order?
Yes,
Only
yes,
that
yes.
meant-
Kindly, that is right
yes,
at the
yes.
end, my lord,
Yes.
the order of
I am
the
submitting.
honorable court.
Show me that order.
Yes,
Yes.
yes.
1048 Annexure 23, my lord.
1048.
And kindly come, my lord, to the conclusion at 1064.
Very detailed order.
Yes, yes. My contention noted, my learned friend's predecessor, his contention noted in great detail. And
Yes.
the reason given, my lords, is
That is at page 1048. Yes, let me submit. Yes, I will complete. Yes, I will complete. There have to get the chance. That is at page 1048. This is the judgment.
1064 at para 12.
Yes, operating person. Last, concluding. It is the stage. It is the stage when the investigation was under process and just before filing of the complaint petition.
No, what the 480 report says.
So 482 says,
From conspectus of the analysis.
it is an investigation now. Yes, madam. Para 10, I will read, madam. Conclusion, man, para 12. I am reading, my lord. From the conspectus of the analysis made herein before, this court is of considered view that the act of registration of ECIR against the petitioner and the investigation inquiry is said to be progress.
Before complaint has come.
Correct. And now please
Yes.
see next page. I
Now, if you will reply into every year, then what is the purpose of my argument? I am giving. If I will mislead the honorable court, if I will say any false fact, then you will mess it. This is the para 12. Against the petitioner and the investigation inquiry is said to be in progress.
I read it.
Yes, ma'am.
Just
On
come
such
to-
basis, they are not amenable to the judicial review of this court in exercise the inherent power under section 482 of CRPC. Further, the present motion, which is at stage when the investigation inquiry initiated on the basis of the ECIR registered against the petitioner, has not culminated in lodging of a complaint under section 44 of the PML Act, is premature. So it is just before filing of the complaint petition. But thereafter, the next page, the order of the Honorable Supreme Court.
This was challenged and the court said that it has become.
Because in the meanwhile.
Yes, I am replying. So, the learned, it is ordered that the learned senior counsel fairly submits that the present special person has become infructuous as the prosecution complaint has already been filed by the and the cognizance has also been taken by the special court. So, what is the purpose of cognizance? Now, the learned trial court, the special court, after evaluating all the evidence, after going through, considering all the evidence, he has formed opinion there is a prima facie case and the cognizance has been taken. So at this stage, already all the materials which are the basis of the complaint petition are available before the Honorable Supreme Court also. Till the date of filing of the complaint petition, the complaint petition was also within the knowledge of the Honorable Supreme Court. There the matter could have been taken. Yes, even if it is filed, we can challenge it also. So they have not challenged it. And all the matters are available by the time of passing the order of the Honorable Supreme Court, they cannot be subject matter of this 482 application. This is my submission. That is on the basis of a decision of Bishamlal Burma case. Your Lordship, please take.
Yes.
Yes, ma'am.
Para?
Well, last concluding para 12.
Yes.
In the case on hand, the filing of the charge sheet and the cognizance thereof by the court concerned were well before the filing of the first petition under section 42 CRPC, wherein challenge was made only to sanction order. That being so, the petition was not at liberty to invoke the inherent jurisdiction of the High Court in relation to the charge sheet and the cognizance order at a later point of time. The impugned order passed by the Allahabad High Court circumstances.
Petitioner in that case might be a government servant where sanction was.
But in that case,
sanction
now,
was not taken.
yes.
So that was
So,
the challenge.
cognizance was taken, complaint petition was filed. It was also laid before the Honorable Supreme Court. The Honorable Supreme Court said that yes, you have challenged the order of sanction because in absence of sanction, the complaint was filed. So that is why now we should not enter into the controversy. Now we open to participate in the complaint petition. Now it is the order has been passed. So now thing is that since 482 application was earlier filed, what was evidence? What are the matters before this Honorable Court? Those matters cannot be now relied upon or can be challenged before the present proceeding. This is my humble submission. So, and on that basis, my first point that the 482 petition is not maintainable because of the fact till filing of the complaint petition, till cognizance was taken, already the matter has been already adjudicated. The same points can be raised before the Honorable Court. That is my main grievance.
Where is that order 140?
1048, my lord. Kindly note, my lord, the department's objection. They raise an objection in that ground that my petition is premature. Then how can he say now that I cannot maintain this petition? He can't have it both ways, my lord.
Because of filing of the complaint petition, you are not limitless. You could have raised that point also before the Honorable Supreme Court. That yes, my argument, my challenge is continuing. Continue
I
on.
cannot raise Milord's a petition, an argument in the.
You have
Supreme
not
Court
challenged that
that
complaint person, filing of the complaint person, though it was brought to the knowledge of the Honorable Supreme Court.
They come to 1065.
10, yes, madam.
1065. What it says is, it has not culminated into section 44 complaint. Therefore, it is premature.
And
In finding that the contention raised by the parties touching upon the merit of the case
Not
are
required.
not required to be gone into. Means the merit has not been considered because it is a premature petition, but it is dealt with all.
Now also, a complaint person cannot be challenged in a regular application. What are the grounds? Whether the complaint person has been filed without jurisdiction, whether there is no material,
that's a.
whether there is an arbitrary exercise of power.
On merit.
It is not an ordinary offense. It is offense under PML Act. Now already investigation is going on. Out of the investigation, materials are available. Those are also filed by the petitioner here also. These are the materials. The materials is that the attachment proceeding was there. And in the attachment proceeding, all the materials were collected. It is involved 130 crores of rupees. And all the documents are also there. He has also filed here. All the documents are there. What can be the ground to challenge the complaint petition, initiation of complaint petition?
Let me, I will tell you what.
When, yes, when already the special court has taken cognizance, the order of cognizance has not been challenged. On the basis, already the step has already been taken. Another step has been taken after filing of the complaint. Now the London Trial Court has already taken the cognizance. Now you cannot say that there is no matter to say that the cognizance is not proper.
You have not challenged the cognizance order.
Not in this, look, I'll have a separate remedy in there. I will challenge with an appropriate.
Yes, yes.
remedy.
No, so no,
That 482 may
this is
not
not
be-
maintainable at all. 482.
Because
Yes,
if I
yes.
challenge in this, then my friend will say.
Okay,
No, no.
today in any case, since I am not able to hear such a volume of thought,
Yes, ma'am.
I am fixing a date.
Yes, ma'am. Yes.
And you address, I am
Yes,
issuing
yes.
simple notice.
Yes, yes. My notice,
In the interim
my notice is not necessary because I have already appeared. Now only thing I will also
To waive notice.
because for issuance of notice also this honorable court to be satisfied that there is a case.
No,
There is no case.
In the earlier earlier 482 petition, since the court says that it is a premature petition, and the contention raised by him today, I have to go into the merits of the case individually. So complete hearing is required for that. So I am issuing simply notice.
Only on the ground of mental only point that since I am raising the only point
Yes,
of
you have
mentality,
raised a valid point.
only on the point of mentality,
You have
may be
raised a valid
decided
point, but
by the next
judgment
date.
which you are relying upon is in that judgment what had happened is in the earlier occasion it was challenged on the only ground of not having sanction. So therefore it was dismissed, saying that since you have not.
But the grounds available was not challenged. Yes, let me. The grounds who are available, who are not challenged, they cannot again raise those points. Yes, my lord, on the ground of mentality, you will also fix it next week or any day.
Hey, all points here are.
Because
Let some
so
judgment,
far
that
the
judgment
mentality
may not help
point,
you. That judgment may not help you.
normally,
But hold up and some other judgment will come.
Yes, yes, yes.
Yes, my lord, the department takes a plea in the earlier round, it's premature, therefore don't hear. Now comes and says, no, even now you cannot argue.
That's the
No,
reason
no,
I am
no.
entertaining, otherwise I would not have done it. When it went to Supreme Court challenging that order, the senior counsel has said that it has become infractuous.
So now,
Because infractuous, because 44 complaint has already been filed.
already filed.
If the 44 complaint has already been filed and merit has to be gone into.
I'm obliged.
Merit, yes, but the trial
So
court.
that- why that statement is made, you know, they will resort to 482 second time. They have resort to 482 second time.
482 is
Otherwise
not
that
a-
statement would not have been made.
482 is not a regular remedy.
A wider remedy in the 482 court, so therefore why should they will try
Yes,
for
yes, ma'am.
SLP?
By the ample power, this one,
They
but
withdraw
482
it and to come and file it now. Very simple. The funda is very simple.
but 482 is not a regular remedy. That in his case, the honorable court will interfere.
And you say that why have you not argued? In SLP, why should they take chance? 482 is a wider jurisdiction, they'll come obviously. They withdrawn and came here.
No, now thing is that on the face of it also, there are no grounds to file a case. Because complaint person has been filed.
That has to be heard.
Yes, yes, yes.
So you tell me the date now.
But my only anxiety
Ma-
is he is to appear on 22nd of February. I'm told the date is to appear, my lord. In the
Before
draft
that, you will also
No,
fix a
much
date.
before that. You
Before
tell me
that.
15, 16,
15.
Will
12.
16th weeks could convenient. your
No
lordship?
problem. I have no problem.
Yes, yes.
You
16,
decide the
16.
date, we'll do.
16th.
16.
Yes, madam.
And you file your written
Yes,
submission,
yes,
whatever,
yes.
maintain.
Yes.
And since the volume is high, big, so therefore let us make it little small.
We'll also make a concise note, my lord, so that we don't have to spend time.
Yeah, so that we need not waste much time.
Yeah, yeah,
Do
Correct,
it.
correct.
Okay, 16.
I'm very
16.
grateful. Deeply open.
Except so Mr. Oh, sir.
I'm very grateful for this accommodation, my lord.
Okay.
Deeply open.
I'll try to accommodate everybody. It's
No, your lordship is very kind.
Thank you very much. Yes.
Item 7.
Waives notice and he waives notice to come up on 16. Yes.
May I please, your lordship?
7, na?
My lord,
Yes.
7. Here, my lord, the informant is the petitioner in the present case. The law and FIR, your lordship, kindly see under Annexure 2, sorry, under Annexure 1, that is registered under section 376 2A.
What are you challenging here?
My lord, here I am challenging that the charge sheet, my lord, the police.
376 2
My lord.
is not
that
made
is
out.
added, that-
Not made out.
Ma'am.
Okay. What is the allegation?
Yes, my lord. In the initial, my lord, your lordship, kindly see.
You are Sarita Kumari.
My lord. I am Sarita Kumari. I am the informant, my lord. I lodged the FIR under section 376.
Okay, you say it is made out.
Yes, my lord. It is made out, my lord.
And he will also say made out.
Yes, my lord.
And the person who is said not made out, we should notice.
Only the accurate, my lord.
Notice. The opposite party number 2. What is the stage of trial?
This trial, my lord.
Acha, you against the final form.
Yes, ma'am.
Likho, then you write it out. The initial FIR is 376.
My lord. Initial FIR is 376.
No. Just see. Very 376.
7, my lord.
354 2 only.
No, my page 7, your lordship, kindly see. 376
oh.
2N 470.
No.
Page 7.
Ah, yes.
My
Top. Yes.
Thereafter, charge sheet submitted, my lord, in lesser.
The petitioner. At the instance of the petitioner, an FIR being FIR number 52 na 62. 62. What is this number?
52, my lord. Adava, PS
Acha,
station of
52 of 2021 in PS Ottawa was registered against the opposite party number 2 under section. Each section likh do. 376 A first likho tapare page kete achi 7. Page 7. After investigation, the police have now filed the final form on. When have you filed the final?
Annexure 2, my lord.
When? Date.
21/7/21. 21/7. That is final report number 18.
21/7.
21.
In the said charge sheet, the offense under section 376, kya kaun thala? 376 2 na?
My lord.
376 2A has been dropped.
My lord.
Full stop. Therefore, the present petitioner, being the informant, is aggrieved and is challenging the final form. Issue notice to the opposite party number 2. Mr. Ragada will notice for opposite party number 1. Returnable within 2 weeks, 3 weeks, to whatever.
2 weeks, my lord, because
2 weeks.
And your lordship fix a date, my lord, for that.
Date fix.
My-
Yes. Next.
Item 11. May I please? So for the present 2 petitioners are considered, my lord. In a 498 case, the present petitioners are the friend of the husband, my lord. Against them, charge has been changed for offense under section 294 and 506, my lord. Your lordship, kind have a glass what allegation against the present 2 petitioners, my lord. That day I have faced, my lord, with the parents-in-law. So for present petitioner, my lord, page 8.
You are Mr. Vivekanand Mahapatra. You are for Vivekanand Mahapatra and also Kumar Sabat. Both of them are friends of the husband.
Husband of them.
Okay.
You will see just page 18 towards last.
Page 18. That is FIR.
That is the
Come
FIR.
to charge sheet. Okay, FIR. Let us see FIR.
What?
Let us see FIR.
Towards last third line. That just the
Page 19 ना?
Page 18 my lord.
Oh,
Page 18.
okay.
Just
ଆମ ଘରକୁ ଆସିଲେ
15 ମାର୍ଚ୍ଚ 2022 କୁ ବିବାହ ସ୍ଥିର କରାଗଲା। ଆମର
ଏକ
ଗୁଆ my lord, that is
ଏନିୱେ ପଢନ୍ତୁ। ହଁ ମାର୍ଚ୍ଚ
ଆମର ଗୁଆ ଅନୁକୂଳ ସତ୍ତ୍ୱେ 7 ନଭେମ୍ବର 2000 ଦିନ 2 ସମୟରେ ଅଂଶୁମାନର ପିତା ଦ୍ୱାରିକା ମାତା ଡକ୍ଟର ଅଶୋକ ସାମନ୍ତ ସାଙ୍ଗ ବିବେକାନନ୍ଦ ମହାପାତ୍ର ପୂର୍ବ ସୂଚନା ନ ଦେଇ ଆମ ଘରକୁ ଆସି ବିବାହ ବନ୍ଦ କରିବାକୁ କହିଥିଲେ। ଅଂଶୁମାନର ବାପା ମୋ ବାପାଙ୍କୁ କହିଲେ କି ଅଂଶୁମାନର ବାପା ତାପରେ ଆସିଲା ଜଷ୍ଟ ପୁରା 3 ଲାଇନ୍ସ ରେ ଡାକ୍ତର ସାବତ ଜଣେ ଉଚ୍ଚ ଶିକ୍ଷିତ ହେବା ସତ୍ତ୍ୱେ ମୋତେ ଅଂଶୁମାନ ବୋଲି ସମ୍ବୋଧନ କରି ଖରାପ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରିଥିଲେ ଏବଂ ଏମିତି ଗୋଟେ ଇଞ୍ଜେକ୍ସନ ଦେଇଦେବି ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟରେ ହାର୍ଟ ଷ୍ଟ୍ରୋକ ହେବ ବୋଲି କହିଥିଲେ। ଦିସ୍ ମଚ୍ ଇଜ ଦି ଆଲିଗେସନ ଏଗେନ୍ଷ୍ଟ ଦି
against Sabat.
Dr. Sabat my lord. So far other petition there is nothing and no allegation absolutely.
Yes, charge sheet.
So, two evidence I have given my lord. Further evidence my lord. That is page 53 my lord. 43. ଅଂଶୁମାନ ଯିଏକି ତାର ଆଇନ ସ୍ୱୀକୃତ ପ୍ରାପ୍ତ ସ୍ତ୍ରୀ ଚିନ୍ମୟକୁ ସାମାଜିକ ଭାବରେ ଗ୍ରହଣ କରିବାକୁ ରାଜି ନ ହୋଇ ଓଲଟା ତାର ବାପା ମା ଓ ସାଙ୍ଗ ସାଥୀ ମିଶି ମୋ ଝିଅକୁ ବିଭିନ୍ନ ପ୍ରକାର ଧମକ ଦେଇ ଜୀବନରେ ମାରିଦେବା ପାଇଁ କହୁଛନ୍ତି। ଏଣୁ ବାଧ୍ୟ ହୋଇ ଆମେ ଆଇନର ଆଶ୍ରୟ ନେବୁ। And page 45 that is mother of the informant matter. ସେଠି ଗୋଟେ ଆଡ କରାହେଇଛି ପଛରେ ଲାଇନ only that much allegation is there. ପ୍ରକାଶ ଥାଉ କି page 45 matter ଆଡ କରାହେଇଛି ପ୍ରକାଶ ଥାଉ କି ଅଂଶୁମାନ ତା ବାପା ଏବଂ ତାର ଜଣେ ସାଙ୍ଗ ଡାକ୍ତର ସାଙ୍ଗକୁ ଆମକୁ ମାରିଦେଇ କଳିଙ୍ଗ ଘାଟି ତଳକୁ ଫୋପାଡ଼ି ଦେବ ବୋଲି କହିଲେ। Except these 3 statements, none else have whispered a single word against the present petition. This much is allegation.
Come to the charge sheet.
Well, yes.
Charge sheet ରେ କ'ଣ ଅଛି କୁହନ୍ତୁ?
Charge sheet matter page 36. After completion of investigation, I submitted full compliance report.
Anshuman, you are the friend of Anshuman.
Friend, Anshuman Satpathy, both the petitioner friend of Anshuman. Vivekanand Mahapatra.
Dr. Ashok Sabat and Vivekanand Mahapatra.
294-506 tax sheet is there.
Charge or intent matter. Against charge matter he has come. 294-506. Charge has to file revision my lord against charge. Or that is revision is against charge.
But Kichi, there is nothing.
Allegations are there. They weren't there.
Allegations of matrimonial dispute to go. ସେମାନେ ଝଗଡ଼ା କଲେ ଏମାନେ ସାଙ୍ଗ ଭିତରେ ପଶି ଯାଇଛନ୍ତି।
For that against them my lord to
how to get out of it this against charge?
So for charge is there are number of Supreme Court decisions my lord. This type of allegations are there. So but except these 3 statements there is nothing. So for section number 1 is concerned there is absolutely no allegation. Neither infrared herself has stated anything, only present at first occasion. So for second of the occasion is concerned that is allegation against Dr. my lord. So far other 2 witnesses are concerned, the parents of the informant, they
have not filed any case for discharge my lord. Against charge straight away come to this court my lord. On charge friend my lord,
you should have filed a discharge. You
they have to file discharge petition there my lord.
Charge has already been framed. If I will file again
and charge my lord already framed on 29/3/2023 my lord. March my lord. Near about going to be 1 year my lord. And in the meantime trial has progressed or not, that is not an instruction with us my lord. If trial has started my lord.
Already considered parents already filed this order my lord. And these 2% are friends my lord.
What is this?
My lord, against parents-in-law my lord.
Parents-in-law.
My lord. Yes.
When this matter is coming up?
20th February.
20th February, issue notice and 20th February. Tag with this. I have already issued notice insofar as the father-in-law, mother-in-law.
For this, there are only both parents-in-law stay here looking at it.
Stay there here. Stay, same order.
So for these 2 petitions.
नहीं लिख दियो in the petitioner is petitioners are the petitioners are co-accused with what is the name of the husband? You are slowly one after another petition you will bring. That's the whole difficulty. Little indulgence you give. First father-in-law, mother-in-law, thereafter friends, thereafter husband.
Ansuman Satpati, send of husband, Ansuman
The there is a matrimonial dispute pending between there are matrimonial disputes pending between one Ansuman Satpati and what is his name? The lady name? You have not implemented lady also. That's the whole difficulty. You want quashing of you. Why have you not implemented?
In that case, I have implemented. So in this case, informant
Where is informant? First of all, your petition is not maintainable. A revision should have been filed. I am entertaining your 482 petition, looking into all these things. There you don't make the party. Why are you creating problem for your client's side? You first implement then. Why indulgence to a person who is so lenient about? You implement and come. Land counsel for the petitioner submits that he would implead the informant in this case. Let him do so within 2 days and let release the matter on 20th February. This is an individual petition. That is an individual petition. Here, charge has been framed, so revision lies. Shall I dispose it of saying that you will file a revision? I am giving this much indulgence because I have see these are friends of some family dispute. These people are unnecessarily roped in. So therefore, I am giving indulgence. And he also took the objection, but lightly took objection, realizing your position. At least petition you should file the petition perfectly. You want some indulgence. Do whatever. Do whatever. Next. 12. 12.
Here I have filed this application excelling the legality of the order dated 14/5/2023, my lord, wherein the Land Court Bureau has allowed my application, but imposing a condition that the present petitioner has to pay
3,25,200
each. I am the owner. I have filed, as per the prosecution case, my vehicle has been found to be utilized for carrying the transportation of the cow, my lord. And accordingly, a case under section 294/506 along with the PC Act has been registered. And after registration of the same, now the present petitioner application of court, he got anticipated bail, one person was arrested, he was granted bail, driver. And in the particular process, when I filed application for release of my vehicle, my lord, which was allegedly.
How many vehicles?
One vehicle. And it has been, the concerned RTO has also valued it to be for a particular vehicle. And thereafter, the court has directed, because in view of the recent amendment, it says, although it is not clear to the extent what it says, while releasing the court also to take notice of the cost which is required for
200 rupees per day.
200 is too much, for human this government.
That is what Supreme Court said. What?
No, not exactly.
Per cattle, 200 rupees per day.
My humble commission for human being, the state has paying around 56 or 60 rupees per day. For cattle, 200.
Here in this country, the cattle are more important than that is 200 at the higher side.
Right.
But that is what
the
Supreme Court
law also says the veterinary officer has to be contacted.
Yes.
Here too. Here, madam may see to the person who has given the one trust. Definitely, the trust will also knows how the trusts are going on. Yes, I don't dispute to the fact that they are taking care of the cattle. But trust report is the
how many cattle you have packed in this car?
11. Only one.
11 in one Tata. Tata is a small one.
Tata LPT, a small vehicle.
So that is the whole difficulty. In a small vehicle, you dump 11.
Small is not exactly small to that basic. It is in between, just like a mini truck. Mini truck, my lord.
A mini truck 11, just imagine.
That is there. That is there. I cannot at the moment.
So then you are agreed only by that word each.
Yeah. First one is each. First and second one is this 3,25,000 was also told.
What is the value of the vehicle?
Value around 6 lakhs or 6.5 lakhs.
Then-
the value
then-
I said.
Then
No, I am ready. But can you see? He has said for cash. I am ready for property security. Malad impose. I am ready for that. More cash,
property, no. See, in the other ordinary condition, property security is all right.
Oh.
But that rule is staring on the face of it. The rule says that the money which will be taken from this proceeding will be utilized for the cattle. So where from this they'll get the money? And as a result, the gosalas are facing problem. You dump the cattle there. Where from they'll get money to feed these cattle?
That is one aspect. My humble submission.
That is the only aspect.
No. I don't dispute that.
In 457 application, in these kind of cases, we have to take care of that also. You have to give money. Some
My lord may say some. I leave it to my lord because
starts from 1 rupee. Will you tell me how much you pay? What I'll make a division. Half of about 2 lakh rupees you pay and rest property security. That is a balancing act.
the vehicle, my lord may see the vehicle. Also
6 lakhs.
The
Vehicle.
vehicle also under hypothecation of a particular thing. So I am not in a position.
So we give 2
last
lakh.
2 years. Last 2 years it is pending.
Give 2 lakh. Do something for the cattle also. You are illegally transporting them and
Yeah, I can not. And one thing I will take note of.
go
Suppose-
see the judgment is taken care of.
Husband,
Go Gyan Foundation.
Yes,
Supreme Court judgment. There only they have said 200
And you
rupees.
see the first page, he has also taken care that all sorts of aspects he has dealt with, and the amount which based on which he has said that is page 8. How he is calculated.
What to do? Unfortunately, I appeared in that matter also, Go Gyan. So therefore I know.
That time, this time, difference. And one thing, Malad may take note of that this particular, suppose after 4 years, 5 years, Malad, if I'll be acquitted, Malad, then once money goes, I don't dispute.
All these things are correct, but the rule says that you have to, the money has to be collected in this way only to feed the cattle and all. 3 lakhs, how much? 3 lakhs?
3,25,000 because why a person has to give once, Malad. Directing an accused to pay 3.25. Also, owner of the to pay 3.25.
Owner is not an accused.
No, owner is the accused.
And
because I being the owner of the particular vehicle, I am also implicated. Now I am on anticipatable, I am not disputed.
That's different.
But my things remain. Now the court will impose some security or some payment to impose to a particular person, not to double. I mean to say, the accused who was driving the vehicle, he has been directed to pay 3,25,000.
now, according to you, you said it has become 650. So I will make 350. 50%. 350, I'll make 350. That's what I'm saying, not each.
Without making any plus 1 lakh. 1 lakh cash security, the rest part,
No, 1 lakh each then. 2 lakh, that's what I'm saying.
They period, otherwise I would not have paid for my friend. And 3 years already, गाड़ी भी भेज दो इस 1 lakh cash security and बाकी rest part property.
Yes, Mr. Garuda, you see.
आज पर दे पर ना जमा पैसा देना है
हाँ?
हाँ, तो भी एक दे दो तो दी पर
पेपर तो किसी पे दो
हाँ, 2 वर्ष दी पर उसी पे गाड़ी 2 वर्ष पड़
The problem is
2 lakhs and
you have to see the practical side of it also. If you impose more, he will not pay. You keep on fighting. That vehicle is also gone, and the cattle are also not getting anything. So let us make a practical order so that at least 1 lakh. I will make 1 lakh each.
Each qualification. I am the owner, and the vehicle is supposed to be released in my favor. Suppose the other person will not come forward and would pay the money, and the vehicle also stand remains.
The 6 lakh, there the owner is also an accused.
That's why.
This is OD 04R8452 vehicle. Huh? Because the petitioner has challenged the order dated. What is this order dated? 5/6/2023, whereby his application for releasing of the vehicle number OD 04R8452
Right.
bracket में Tata, what is this Tata
मालूम है Tata LPT
Tata LPT
4825
हाँ
BS Romanic VI
yes
10X2
page 8
अच्छा
was has been directed to be released it was not confiscated, it was seized only. Directed to release. However, a condition for depositing. Where is that condition? Which page?
Page 9, madam.
9. He shall file an indemnity bond. Where is 3 lakh 6?
He has said in.
He has not said anything.
No, my lord, is there.
ଆଉଗୁଡ କେସର ପ୍ରେରଟାକୁ ଆଣିକି କରିଦେଇଛନ୍ତି ଆପଣ ହଁ ଏଠି ଅଛି 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 the petitioner and accused shall pay sum of rupees so each towards the expenditure of the cost regarding the maintenance of cattle which were kept in Jimma, and the petitioner so stating that the seizure vehicle so is not required for the investigation of the
The petitioner challenged orders to confirm answer the page whereby the application for releasing its vehicle for answer has been directed to be released.
With a certain condition. He is agreed by the said conditions which reads as under. এটা পড়ো এটা দেখো পেজ 7 80 লেখা আছে এ র এ খালি এ only এ তଳେ এ র পেজ 7 ର লাস্ট রে এ ଅଛି এ ଖାଲି এ ହିଁ ଲେଖିବ
পেজ 7 টা পেজ 8 হবো
পেজ 7 and 8 ର এ
পেজ 7 টা পেজ 8 হবার কথা ସେ ଭୁଲ
ও ଆମର ଏଠି ତ পেজ 7 ঠিক আছে ହଁ 7 ର ଲାଷ୍ଟ ঠিক আছে Let the counsel for Mr. Chand appealing for the petitioner submits that it is virtually impossible for his clients to make good the condition for release of the vehicle. Therefore, he seeks leniency. Mr. Ragada, the counsel for the state submits that under the which act is this? Prevention of Cruelty Act. The release of the vehicle is required to be conditional. The cost realized from the condition would be utilized for the purpose of the cattle, upkeeping the feeding the cattle. Full stop. Taking into consideration the facts of the present case, I am of the opinion that the conditions so imposed needs to be modified to the extent that the owner of the vehicle.
Clause number 8,
condition imposed as a cause A, I have reproduced to the extent that the owner of the vehicle shall make a deposit of rupees 2 lakhs, 2 lakhs. And 2 lakhs, 2 lakhs for the purpose of releasing of his vehicle, and insofar as remaining 1,25,200 is concerned, he would furnish a indemnity bond. With such modification, the petition is allowed.
2 lakh.
Owner pay kuchu. No, each korea padibo.
Why I am saying so, my lord has kind enough to do that, my lord. Related to 1.5 lakhs. He paid no loss. Again, I have to come. 2 years, last 2 years, the vehicle has been kept maladed.
The very fact that they have engaged him indicates that he is capable of paying.
No, I will see about 9 months, 10 months before it has been filed.
They become poor now after engaging you. So 1.5.
1.5 rest.
अब रेस्ट कर दो माइनस कर दो कितने 2 पॉइंट है ना 125 200 था ना 225 200 को डिविडेंड माइनस कर दो नहीं ठीक है
I'll indicate whether instead of each because they
I have only owner will do.
Yes, I'll indicate that.
I have
Otherwise-
indicated. I have don't worry. The same shall be done by the owner within 1 week from today.
Yes.
Immediately you give so that at least 1.5 तो मिलेगा कम से कम होगा हाँ ठीक है next
35 my lord I was directed to file a consolidated petition. I have to file that.
You file? You want
I
to
have
file?
not filed, I will file today, Your Lordship. I will-
Here in this case, my lord, I have filed application that is CLMC 1313 of 23. I am for the informant. There is a direction to conclude the trial. There is period of 6 months from the date of order. That is
That was brought to the
1/5/23.
notice of this honorable court and thereafter
And
stay was granted.
in the meantime, my lord, what happened on 22/6/23? Charge has already been framed and for direct evidence for evidence, my lord. Now he has
Everything was brought to the notice of this honorable court, thereafter stay was granted.
thereafter
Whatever my learned
that
friend is submitting, Your
what
Lordship,
happened, my lord? Thereafter
everything
the
was
matter
brought
has
to the
come
notice.
before the honorable court. Court
You
in
got
this-
a stay in September
Yes.
23.
Yes. Everything was, whatever
Your
my
Lordship
learned
kindly
friend is
bear with
submitting.
this order.
So I will file one consolidated petition,
At
thereafter Your Lordship may hear it.
Time and again, my lord, they have.
That's the whole problem in 482. If once you get a interim order, this is the problem. So that is the reason I don't give interim order at all.
No, no, my lord.
You have a merit, argue and finish it up. Otherwise, what happens is once you give
No,
the
no,
merit
my lord,
and it is
My lord, certain
piling up on
other
it.
things are required, my lord.
How much time will you take?
But what has happened now, the present petitioner is suffering from neurological problem. He has gone to Bangalore. That is the whole problem. Otherwise, my lord, I should not have.
He having, my lord,
My lord,
4
there is a
cases in
certificate.
his credit, my lord.
My
He is a history sitter. And there is a direction, my lord, to conclude the trial.
Lordship
my
may
lord.
kindly
Your lordship kindly peruse the
So
order.
he is rightly employed him.
Not a medical problem is there, my lord. Your Lordship may take it one month after.
Okay, I'll
thereafter.
take it face value. This is being a last and final opportunity.
My lord.
By way of last and final opportunity, Mr. Mahapatra seeks further time
My lord.
for filing consolidated petition. For the said pair has been vehemently opposed. By way of last and final opportunity, the matter is adjourned to 6th of February.
Also, 1 month time may be allowed.
No 1 month. 6th February. Otherwise, I'll vacate and take 2
No,
months.
Your
I'll vacate the
Your Lordship may be pleased.
6th February. 6th February.
Interim order may be extended.
Interim order to continue till 6th February.
My lord.
Obliged.
Diploma.
I'll not 6th February. You
No, my
want
lord.
to- I'll not pass any order. Then it goes.
46.
Interim order is the biggest problem. 46. Yes.
Here is a case matter which has been filed by the present petitioner, who is a complainant. My lord, he has filed a complaint case before the court below, and it was sent on 150/3 for registration. The order was passed in the month of July, my lord, 25/7/2023. But till date, no FIR has been registered. Last time I was directed to take whether any FIR has been registered.
156(3) order is made.
153, no, it has been, yes, order has been sent for registration. But till date, no FIR has been registered. In the meantime, good sense prevails between the parties, and somehow, my lord, the complainant now interested not to proceed against the complainant in the accused persons, who are 37 in numbers, including ladies and all those persons. And thereafter, my lord, he has filed application before the concerned CSC. She has filed an application under 257 CRPC for withdrawal of the complaint, because she doesn't want to proceed further, and law also provides that at any stage the complaint
withdraw,
can. Now the court below has rejected the application only by saying that since I have already sent, I have no power.
Exercise.
Since
that has not
complainant
registered,
herself went to the court.
Not registered till yet. So it is as a complaint case. Though it is sent to the PS, but that has not registered till yet. Your lordship, up to your
Go.
lordship.
So the petitioner has filed the present petition seeking quashing of order dated 25/7/2023 passed by the learned court of so and so in one CC case number 26/2023, whereby the application moved by the informant, that is
Petitioner.
Petitioner is the informant.
petitioner,
Complainant.
application moved by the complainant, that is the present petition, for seeking withdrawal of his complaint has been rejected. Full stop. It appears from the order that the sole ground of rejection of the complaint is that the application, the complaint of the petitioner has already been entertained under 156(3), and the court has already directed the police to raise an FIR. Therefore, the trial court is of the opinion that under section 257 CRPC,
The petition is not
complaint cannot
maintained.
be withdrawn. Complaint cannot be withdrawn. Therefore, the petitioner, being the informant of the case, invokes the inherent jurisdiction of this court under 482 CRPC. 482 CRPC. The 482 CRPC. In the present case, Mr. Ragoda appears for the state and submits that although there is an order of 156(3) made by the court below, but till date no FIR has yet been registered against the opposite parties in this case. So therefore, full stop. Therefore, there is no impediment, legal impediment, for quashing the proceeding, quashing the complaint at this stage. Having taken into consideration the facts and submission at the bar, I am of the opinion that the application under section 257 CRPC moved by the complainant to withdraw withdraw his complaint against the accused persons before the registration of FIR, as directed by the learned trial court under section 156(3) of CRPC is maintainable, was maintainable. Therefore, the complaint filed by the petitioner against the accused person, namely the opposite parties, is quashed. Complaint number. Complaint number.
Pending in the file of
pending in the court of quashed. Yes.
The complaint, the petitioner will send the copy of the order to the police station. Otherwise, they will again register.
Yes, my lord, may indicate that.
The petitioner,
On production of
Mr. Chand undertakes that he would
submit,
take the copy of this order, certificate copy of this order, and inform it to the concerned police station.
Who will act accordingly?
Concerned petitioner and the concern, the IAC of the concerned police station will act accordingly.
48, my lords. May I please your lordship, my lord? This FIR criminal law has been set into motion, my lords, at the instance of my cousin brother, my lords. Your lordships will see the FIR at page 8. The offences are under section 379, 406, 420, 506, 294. My lords, the allegation starts from page 10 onwards. My lords, I'll read the entire allegations. Your lordships will see none of the... My lords, here the case is that the present informant was not taking care of his parents. They were under my care. I disposed of a property which was around 4 crores and the amount came to the account of his father. When the amount came, my lords, he came into picture and he is now saying that I somehow tried to manipulate that property and sold it. There is no complaint by his father. His father is alive. During the lifetime of the father, can the son bring the complaint against me with respect?
Self-acquired property of father.
It's an acquired property of the father, my lords.
Father doesn't have any.
Father does not have any case. The son comes and brings up allegation against me, and the only allegation now is against me of rupees 7 lakh.
What is the father says?
Father, he has no complaint against me, my lord.
No, what is the age?
The
Whether
age of the
he is capable of understanding what is
he was
happening?
capable. He was 90 years, my lords. He was 90 years of old, but he was never taking care of his father. My lords, I have not disposed of the property, and the amount is in his account, his father's account. The apprehension was I could have taken that amount. I have not taken it. My lords may see the FIR.
You have not taken it because of the FIR has come.
No, my lords. No, my lords. They say the FIR. In the FIR, they say I could have taken the amount. There was a check
No,
of.
that is that money which has come on account.
My lords.
Maybe the white money.
After selling a property,
cash,
my lords.
Cash property, cash you might have.
No, that is not the allegation, my lords. My lords, the allegation is simply, my lords may read the allegation at page 10.
Sum of 4 crores, 6 so-and-so
Was kept after selling land, and one of my distant relation, namely Tarapad Mahanti, the present petitioner, grandson of Sri Nisamani Mahanti, staying near Lakshmi Mandap, used to visit my father at my
taken a check also, 90.
My lords, the check if I have taken, there is no question of forgery here. There is no allegation of forgery. If I am depriving
Have
any.
you encased that check?
My lords, that check has not been encased, my lords. He has made the stop payment of that check. That check has also not been encased. My lords, now he is trying to compromise with me, my lords. If your lordship will issue notice, my lords, he will compromise.
Oh, that is a better idea.
My lords.
Issue notice. Issue notice, returnable. Bring him.
My lords, he is not coming, my lords. If the notice goes, my lords, your lordship knows brothers are the two better enemies than the real enemy, my lords.
No, better, brothers are also sometimes friends.
At times, but in this case, my lords, when he has not taken care of it.
I'll take it up on 6th.
My lords.
Take the notice.
My lords.
Dasti and serve on what?
My lords, I'll serve Dasti.
Now investigation only.
My lords, investigation.
So therefore,
no coercive measures in the meantime against.
What are you talking? I'm a bail court.
No, my lords. In the meantime, my lords, if
I'll stop the investigation.
My lords may only issue notice.
Can I stop the investigation?
No, my lords. No, investigation may go on, my lords.
I understand it. Must be.
Anticipatory bail has been done. I have given that certificate also.
But you better you serve because his brothers and all.
Dasti, my lords. Dasti.
Dasti. Take Dasti 6th.
49. Grateful.
Yes.
Also fixing it to 6th, my lords. On 6th.
6th.
May I please, my lord. My lord, here the order dated 24/4/2018 passed by the Law and Court below taking cognizance of the offences on section 417, 323, 376B IPC has been challenged, my lord, on the ground that this is admittedly a matrimonial dispute. And there were as many as 3 to 4 cases. All the matters have been settled in the court below. However, this being an offence which is triable by Court of Sessions, we have filed this application, and my learned friend is also appearing for the informant victim.
What is the offence you said?
Offence, my lord, 417, 323, 376B.
376.
376B. Cohabitation by the sexual offence by the husband with the wife during separation.
1918 of 2020. I am subject to correction.
Is it?
CRLMC 1918 of 2020.
Oh, that was dismissed perhaps due to non-prosecution.
No.
That is dismissed.
You have mentioned at the page 2.
That is dismissed for non-prosecution.
Dismissed for non-prosecution.
Yes.
What was that?
That was also filed for the same grievance. For the same grievance that was filed, but due to my non-appearance, that was dismissed.
So you should have restored it. Why a fresh one?
Would have, since I have filed another case.
Why?
I am filing a memo that if at all it is pending, let it be not pressed.
No,
but to my instruction, it has been dismissed for non-prosecution.
That's right. If it is dismissed for non-prosecution, you can revive that.
Yes,
instead of filing a fresh
been.
one.
Since it has been dismissed, so we have filed another case.
If some inconvenience takes place, you don't prosecute that. It is dismissed in default. Bring a fresh one. What is this practice? Call for record of that.
Yes.
Let us see. 1918 for 2022 and urgent to 21st of 22nd. Let me see that. Generally, once it is dismissed for the same cause, you have to revive that petition only.
Right.
There is no legal bar to bring 482.
There is
That
no
doesn't
legal
mean that you can jump the procedure. What
Yes.
happens is, suppose you file it today. If I'm giving a practical example, suppose you file it today. Suppose the court is not with you. Tomorrow you don't come. Somehow you have managed an arrangement, you don't come. It is dismissed in default. And keep quiet. Then assignment changes, you go to some other court, file a fresh one. Is it not a practice of bench changing? It's absolutely a practice of bench changing. It is not permissible under law. So therefore, let us see that. I will restore that and send it to. We'll see that.
Oblige.
Maybe I'm just giving a.
Yes. Yes.
I know that you people will not do that. Still, we have to be.
Yes. That has been dismissed for non-prosecution.
I'll call for the record. I'll just
My lord.
entertain it. No
My
problem. Huh? 21st. 21st of this.
21st.
February.
My lord.
Will do. 50. You have settled the dispute?
Yes.
Then you issue notice also. Meanwhile, why to waste?
Yes.
Issue notice to opposite party number 2.
Opposite party number 2.
Mr. Maharaj waits notice for opposite party. If he comes, then
Yes.
we need not go into all these things.
On the very day, it can, my lord, can also dispose it of. Oblige.
Requisite, file the requisites.
Yes. 21st, my lord. 21st.
Yes. Item 50. Guardian. 51.
May I please, Your Honor? Here I have come for questioning of the FIR mailer. Allegation under section 467, 468, 471, 421, 34. There are two accused mailer, father and daughter. Daughter is before the lordship mailer. So far as allegation of taking money, every transaction has been made by the father of the petitioner. And the daughter at the time of registration was only 18 years some days mailer. He is only the signatory mailer. The land for which the money transaction has been made was in the name of the deceased mother of the petitioner. After the death of her mother, the same was
Father also died.
My lord?
Father also died, mother also died.
No, father is there. Father is an accused here, my lord. I only come for the daughter, my lord. He is reading in +3 science, my lord. Your lordship may see the FIR, no allegation against the present petitioner. Because he is the one of the co-sharer of the land, he has only signed the documents.
Show me the age,
my lord. Age I have also mentioned in my cause title. And
cause title will not make. Show me
the-
some document.
Date of birth is
Your 20 years.
your lordship also can add the annexure 3, page 15, my lord. That is the annexure 3.
Annexure 3
My lord.
is legal heirs.
Legal heirs. The petitioner age is 9 years, my lord. At 13. 2013 रे बाहर था 9 years.
Offense क्या bro?
Offense is 2022, my lord. Sorry, 21, my lord.
21.
My
That time is
And
19.
that time is 18 years, some 17 days. My lord. 18 years, 17 days. My-
It was disposed upon 1/8/2022. Direct was given to this month on merit that it was disposed of. Direct was given within 3 weeks. He used to surrender. He did not surrender.
No, my lord.
He filed an application for extension of that surrender period.
Hmm.
That application was also allowed subject to payment of ₹500 cost to be done. That has not been done.
Yes.
No, my lord. He has already subsequently another modification was filed. That part of the cash security, my lord, and it has been modified. Your lordship may see the trial court.
Anyway, but now you have
I am
complied the order, surrender.
My lord.
And you are on bail.
My lord.
You are on
You
bail.
are I am on bail and I am continuing in my study. my lord.
The only thing is, she was a minor that time when the offense has taken place.
That is 2022.
22.
18
See,
वर्ष
the document, if you see the document in Annex 3, that was issued on 2013. She was 9 years. In any case, even if he's 19 year or 20 year, she is a student. Father might have done something, or mother might have done, merely because she was one of the co-sharer. Do you think that this career of this girl should be jeopardized? We'll issue notice. We'll see. Issue notice. Where is the informant?
Informant.
That's the whole difficulty. If even the court want to help you, you render yourself helpless. This is their minimum thing. It's 420, 468, 471. I will quash without the informant also. It's the property purchase and sale.
I'll make it.
The state wants to help you, court wants to help you. You don't want the help. Because these so casual petitions I have never seen in my life. Very casual petitions. Charge sheet has been filed?
Charge sheet, I tried to take instruction today whether charge sheet has been filed or not. But he is reading at here at Kotak, my lord.
You have not filed the petition on her behalf. The father might have instructed you.
My lord.
Don't say that.
Father is also here at Kotak, my lord.
So then he doesn't know whether charge sheet is filed.
He has stated that I will take instruction.
Twice you came to this court for anticipatory bail. You have no knowledge. You must be having full knowledge. You don't want to disclose, that is a different story.
At the time I filed this case.
File a better petition and come.
At the time I filed, the charge sheet was not filed. At the time
Whatever
I filed,
you want to file.
but whether in the meantime it is filed or not, I will take instruction.
You do whatever, but file a better petition. I will not advise you as senior advocate. Why should
Liberty may be granted too.
No, what liberty? You have liberty always. I'm just adjourning it. You do needful. Meanwhile, if you want indulgence of this court.
My prayer is, I have prayed for file a better petition.
I'm allowing it, not that you can't file. You file it. You file it. Don't dispose of. Simply adjourn. He will file a better. You file a better affidavit or whatever. Give date somewhere. 22nd, 23rd, 23rd. Next.
52.
Yes.
Matter on the basis of the compromise. On the last occasion, my lord has directed to remain present of the parties, and accordingly, the parties are today before your lords.
They are there. Come. What is the
offense is 498 to 494.
498. ठीक है सुन भाई वो लड़ रही दिलीप कुमार नाइक who is दिलीप कुमार नाइक दीपक कुमार नाइक sorry and Sarath Chandra Naik, Sangamitra Naik. They started staying together.
They are now staying together. They are
the petition First program for agencies. The petitioner has filed the present petition under 482 CRPG for seeking quashing of FIR number so. Next program. The parties have settled their dispute. The present petition is arising out of a matrimonial discord. Okay. The parties have settled their dispute. And they have filed a joint affidavit? No.
Joint affidavit?
Short on. File करते Fine. Compromise deed है.
Base 30.
They have placed on record a compromise deed dated 3rd October 2023.
For the
ठीक है 3rd October 2023 entry alia stating that they have settled their dispute and the opposite party number 3 being the wife of the petitioner started residing with the petitioner. They want to the opposite parties have decided not to proceed against the petitioner and lead a marital life. The parties are present in the court. They are being identified by their respective counsel. They have filed their self-attested photocopy of their Aadhaar card to establish their identity. And Mr. Maharaj, Mr. Maharaj appears for the state and submits that since the dispute is essentially a matrimonial dispute, and the parties have settled their dispute, and also they are staying together. So therefore there is no legal impediment. There is no legal impediment in quashing the FIR, taking into consideration the aforementioned facts and circumstances of quash. Okay, quash. Okay. Chalo ji, आओ.
May I please?
Yes.
Alleging the issuance of NBW, madam. Petitioner was on bail, madam. Bail order was
When bail?
24/4/2017, madam.
On
And
24, hey, bail. Yeah,
I have annexed the annexer 2 is the series, madam. Bail order.
Bail jump. He is on bail. When you got the bail?
Bail, he was on bail on 24/4/2017, madam. Thereafter
24/4,
NBW
2017.
NBW issued on 12/5/2023.
12/5/2023 NBW. 1000. See the distance. 2017 to 2023.
No,
I am looking at that distance.
NBW issued 2023.
So therefore 1000.
Yes, ma'am.
You surrender within 15 days and will whatever remedy. You are on bail, of course.
No, my lordship granted surrender, he will release on bail subject to payment of cost.
He will subject to court. He undertakes to appear on or before
I could
on or before 20th of February.
1000 cost.
1000.
लॉर्डशिप बेल्जियम में लॉर्डशिप इंपोर्ट 17/9/2014 लॉर्डशिप
Right on the bail
लॉर्डशिप
केबे bail ହେଇଥିଲା
बेल मो 10/8/2009 बेल ହେଇଛି
ଲେଖନ୍ତୁ 10/8/2009
9 बेल ହେଇଥିଲା
ବେଲ୍ ଆପଣଙ୍କ ଏମ୍ପି ନୋଟ ହେଲା 2014
ଲॉर्डशिप
ଏବେ ଆସୁଛନ୍ତି 10 ବର୍ଷ ପରେ
लेबर फोर्स
ହାଁ
लेबर फोर्स
10 ବର୍ଷ ପରେ କାହିଁକି ମନେ ପଡିଲା ଆପଣଙ୍କୁ 10 years just imagine
लेबर क्लास लोग
offense କଣ
376 लॉर्डशिप out of love relationship the indicated report.
If he doesn't appear, then unnecessary 1000 first.
55. Also, my lord, Belgium matter. The NBT will issue, my lord, 6/7/22.
नहीं bail कौन तना कभी
Earlier, my lord, bail, my lord, 2/5/19.
2/5/19. And how NBW issued on
6/7/22.
6/7/22. कितने 500 कम डिस्टेंस चलो 500 नेक्स्ट
56.
settle
No, it cannot be settled. My lord, may kindly see one thing. My lord, here I have been convicted under 138 of the NI Act. I filed an appeal. In the appellate court, as per provisions, I have been asked
20%.
20%. I have prayed for installment, which the learned trial court rejected. Last occasion, your lordship asked me that whether such an installment can be allowed or not. There is a judgment of this honorable court. You are not, this is nothing between you. You are not supposed to.
I am not entitled to say anything.
Definitely you are entitled, sir. You have filed a wakalat now. I'll hear you.
Your lordship issue notice to me. Not
I'll-
that I am so much.
Yes, I'll hear you.
Your lordship may kindly
Which
turn to
Which paragraph?
paragraph 9. Considering the submissions of the learned counsel for the respective parties, since the petitioner is now prepared to deposit 20% of the compensation amount, the court is of the view that he should be allowed to deposit such amount in compliance with the order of the learned appellate court, which is then to pass an order with regard to suspension of sentence in terms of 389 CRPC. Furthermore, there is no provision in 130-148 of the Act which allows deposit of 20% fine or compensation amount in installment, but having regard to the willingness of the petitioner and the facts and circumstances peculiar to the case, the court in exercise of inherent jurisdiction should allow it in the interest of justice and directed 20% of the compensation amount, which is 4 lakhs for such and such, in terms of installments. And the learned trial court has also in compliance to your lordship's order, has done this in another case, same ADJ court.
Okay, one is enough. What do you say?
The appellant asked for 2 months time. Is already elapsed by.
Now he is ready to pay 20%. You take it.
That is there in the order sheet, my lord. I kindly see page 7.
7.
They pray for 2 months.
No, 2 months. I understand it. 2 months at a time he can't pay. That is the reason he says that.
Only 2 months expire within a week. What?
Why are you unnecessary into small technicality and let you ultimately your check amount has to be recovered. He is convicted. 20% he has to deposit and face the appeal. Appeal will be dismissed. You get it.
What I submit, my lord. They already pray for 2 months time, which already expired. So question of modifying his own prayer, how it can be? Because
you are correct. I am not, but you are absolutely correct. I understand it. Not that
they pray for 2 months time.
I understand it, but now since there is an order of court, modified the said order allowing the installment to pay. Kindly see the prayer.
No. Then at trial court, they pray for 2 months. They already expired or within a week. So let prayer be allowed. What I consider.
482 petition prayers, just see.
The lower court, in lower court, they pray for 2 months. That is reflected in the order.
See 482 prayer.
And they made a state as a party. And how the state council accept notice on behalf of the state is a 130 NI Act. I can't understand.
I am made in party because I am challenging the court order. What is this technicalities, my lord?
No, it's all right. Nothing to be.
My lord, I have made the state a party. I want to contest with the state.
Are we not wasting our time in all this?
They pray for 2 months. They already 2 months expired.
Okay, I'm relying upon this order installment and be happy with that installment. But you see, this order is left open.
Yes.
Installment.
But
I can't left it open like this.
By the learned trial court has fixed the installments. Your lordship, that second
In
order.
this case.
Yes.
In this case.
In this case.
Show me this order. Now I will direct the trial court to fix the installment.
Yes, my lord.
Installment, keeping in view the your conduct also.
Yes, my lord. Yes.
Bad by lordship, sir. But they pray for 2 months in their trial court.
That is why I am saying the
What is my prayer in the 482? Let him see.
Lego. The petitioner, 1 minute. The petitioner has filed this present petition seeking quashing of order dated 6/12/2023, whereby his application under section 148(2) of NI Act has been turned down. The application under 148(2) of NI Act moved by the appellant seeking 2 months time to deposit 20% of the check amount. Has been
compensation amount.
Compensation amount has been
at 36,75,000, 20% is 7,35,000.
Yes, has been allowed, but his prayer for payment of the said amount, said 20% amount, that is 7,35,000 on installment, has not been acceded to. Therefore, he has filed this present petition seeking intervention of this court to allow him to deposit 20% of the check amount, that is 7,35,000 so and so on installment basis. So, Mr. Bose, to substantiate his argument, is relying upon an order of the coordinate bench, order of the coordinate bench passed on 14/2/2023 in CRLM MC 489 of 2023. 2023. He is emphasizing in para
9,
9, 10 and 11. On the basis of next further he submits that pursuant to the aforementioned order in the said case, the learned trial court has fixed the installment. Good, sir. Relying upon the aforementioned judgment, aforementioned order of the coordinate bench, he seeks similar order. Mr. Mishra,
I'm A.K. Budhia.
Budhiraj, appearing for the respondent, public complainant, in the complainant is vehemently opposing the prayer on the ground that the indulgence given by the trial court for depositing the 20% amount within 2 months has also expired, and so
No, it is not an expired. It will expire next.
They pray for 2 months.
No, sorry.
They pray.
Yes. What have you written?
Not on the instance of the court.
That the prayer made by the petitioner seeking extension of 2 months for depositing the 20% amount was allowed by the trial court. So therefore, he has no cause to maintain the present petition. Taking into consideration the aforementioned facts and circumstances, the present petition is allowed, directing the petitioner to deposit the deposit the 20% pre-deposit conditions, to comply the 20% pre-deposit in installment, and the trial court is directed to decide the application, fixing the installment, taking into consideration the facts of the present case and conduct of the accused person. Allowed.
Your lordship, kindly pick the period within 3 months or 4 months or whatever it is.
Well, that the trial court will decide.
Trial court will fix, taking into the conduct.
Yes. Trial
Then
court will
your grievance is the same shall be done within 15 days hence.
Yes. My lord, can I take back the certified copy?
Yes. You keep that order sometime.
Photocopy I have given. And the
keep-
trial court photocopy also given.
Similar case, if it comes, then you tell me.
Well,
Yes.
grateful man.
Yes.
The
57.
state is getting. Well, in this case, I'm for the petitioner, my lord. I have challenged the order passed by the non-magistrate, my lord, JMFC Dhenkanal, by the annexure 2, my lord. That petition has been filed by the complainant with the opposite party, my lord, under 143A of NI Act, my lord. And the London magistrate directed to deposit 18% of that amount, my lord. That's the check amount. I have challenged that order before your lordship, my lord. At main ground, my lord. If lordship can see the annexure 1, my lord, the petition, my lord, that the transaction year in the year, my lord, 2016, my lord. The act, my lord, the 143 came into force, my lord, 2018, my lord. Since the transaction is the year of 2016, my lord. That
143 is just
lordship.
applicable to the pending cases.
Lord-
Prosperity in natural words.
Lordship.
Prosperity in natural words.
But here check is issued on 22/4/2019.
That is disputed, my lord.
Complaint filed on 2/7/2019. After the amendment also.
The entire transaction, your lordship.
Transaction, forget about. The cause of action arose on the date when
Cause
check
of
was
action are
issued.
in the, my
Check
lord.
was issued, not on the transaction. Transaction you might have done 10 years back, but if you given the check is the cause, not the transaction.
But that check is my disputed, my lord. That my stand is I am
Disputed, I am not on that.
that I am not issued that check, my lord. That is disputed, my lord.
Where is your that is on merit again, but where is the reply to the statutory notice?
My lord.
In the reply to the statutory notice under 130.
That reply factory, my lord, in the trial court, my lord, there is communication between the petitioner and his advocate, my lord. For that he has given no objection. If that amount will, lordship can see the order, my lord. He has given no objection if that petition will be allowed. Lordship can for a moment.
What no? I didn't follow. To maintain a petition, the complaint under 138, there should be a statutory notice.
My lord.
Have you received the statutory notice?
My lord, that I have received.
You have received?
Received, my
Have you taken the stand which you are telling today?
That
not
notice
issued by me?
That notice is not available. Lordship,
Then the presumption under 139.
Then lordship, keep it next week. I'll file the entire document. Next week.
See, these are minimum thing. At least you must think that at the High Court level, these questions will be put to you.
That is the
The presumption operates against you. You are out.
Well, then lordship, given short date next week. I'll
You have interim order in your favor.
My lord, the NBW has been issued, my lord. NBW has been issued.
Why don't you go and appear?
Then lordship decide the matter, then I'll appear. If you're liable to pay, my lord, then I'll.
Very clear.
See whether you have issued the check or not. That is a tribal thing.
For that reason, that is a criminal case.
Only the question is 143A compliance.
My lord.
143A compliance. It is prospective in nature. It's all right because the procedure is prospective. Prospective in nature. It is not a substantive thing. So when the cause of action arose, cause of action insofar as 138 is concerned, arises on the day when the check is issued. Thereafter it arises the day when it was dishonored. Thereafter it arose the day when 138 notice was given.
That is, my lord,
all these things.
the answer is the answer is that.
Taken care of for the.
That is a different story. That is different.
Then lordship, next week I'll participate.
Put it in next week sometime. You come with all this.
The
8.
Yes, please, your lordship. Your lordship, an application challenging the order dated 16/8/2021 passed by the additional session judge Devgan in connection with the 2B/CC case number 47 of 2019 under section 51 of the Wildlife Protection Act 1972. Then now is pending.
What is the stage of the case? Last order it says that the call for the report from JMC, JMFC Devgod regarding the
report from the Lana JMC Devgod.
Where is that report? Has it come? Has it come? It has come, it seems. It has come. Why for it was called for?
I am not there, my lord. The petition is the release the gone. The petition is the license holder of the gone.
There is something to do with investigation officer.
Well,
It
2019.
says that with reference to the subject above, I am going to state that in so and so is at the stage of awaiting sanctioned PR from the investigating officer. And this court has communicated the fact for non-submission sanction of PR to the concerned DFO Devgod. If you have not done it, the case is up for 2019.
Yeah, lordship.
You don't want to prosecute, then we'll quash it.
Yeah, lordship, that matter will be damaged because of. In fact, he had the application for a release of gone, my lord.
That's right. That is why last order, just see, last order, the court wanted to know what exactly is happening. The report was sought. Report now is submitted. It says that you are not able to produce the what is that PR, what is that sanction, PR sanction.
But then my notice my lord, the letter issued to the my lord, the IAS my lord on 29/9/2020.
Why should the court will be blamed for this?
My lord.
Because of inaction of the investigating officer and whoever did the.
Last chance पे given my lord, any term and condition release. The Forest Act release होने से सिर्फ reject है जी. No, no role of the petitioner has no role.
Court wanted to know why this happened.
On 29/9/2023, my lord, notice, my lord, Supreme Court.
See, wide order dated, likho, wide order dated, order dated 29/9/2023, the coordinate bench of this court directed the learned JMFC Rimal Devgarh to inform this court the stage of the trial and the number of witnesses who have already been examined. In pursuance to the order dated said order, the JMFC Riamal has submitted a report inter alia stating as under. ये report दे दो, report office of the ये stage of कौन report दी? This report is also nothing. Witness, how many witnesses are examined? Nothing is there.
We had not given my lord but on 30/9/2023 notice letter issued to the IH my lord.
नहीं, how many witnesses are examined?
That is not there.
See this, लिखो report stating inter alia, वो लिख देना full stop. The report is incomplete. Report is incomplete and is not in consonance with the earlier direction made by the court. Therefore, the JMFC is further directed to submit a report in this court as per the direction dated 29/9/2023. Mr. Rogada also submits that in pursuance to the report of JMFC dated 5/10/2023, he would seek instruction from the investigating officer. Investigation by next date of hearing. ଆପଣ ବି ପଚାରିକି ଆସନ୍ତୁ କଣ ଇନଭେଷ୍ଟିଗେସନ ତାର ରିପୋର୍ଟ କଣ ଦେଇଦିଅ ଡେଟ୍ ହଁ ନେକ୍ସଟ
59 and let's say 600.
Yes, 59.
May I please your lordship? May I please your lordship?
Yes, tell me. You have lost the energy waiting for longer time, it seems. Yes. What is your case?
My case is, my lord, the order
Speak
dated.
little louder.
The order dated 19 May 2022, passed by the learned SDJM in Dhenkanal, framing charge under section 446(1) CRPC is under challenge one part. Number 2, the entire prosecution of the complaint case is also challenged. Now I'm submitting the first one.
You are asking for quashing of the entire ICC case.
Number 1. Number 2.
Number 1 only number 1 prayer. There is no other prayer.
Another
See the
prayer.
prayer in the 482. You are asking number 1, number 2. Where from you are getting number 1, number 2?
It is therefore whether this honorable court.
I read it out. Tell me. I read it out already.
Yes, ma'am.
Yes.
So the order dated 19/5/2022, framing up of charge under section 446(1) CRPC is impugned before my lord.
Why?
Because the complaint case has been filed by the complainant for commission of offense under sections 341, 294, 323, 506, read with the 34 IPC. Lord and Magistrate took cognizance on self-same offense, and thereafter the accused persons were on bail, the petitions were on bail, and while framing of the charge, the Lord and Magistrate, without asking the complainant to adduce evidence, giving opportunity of a cross-examination to the accused persons, to the complainant, they have been taken framed.
Where is the question of giving cross-examination and all and pre-summoning, pre-charge?
Yes, my lord.
Where from you got that concept?
And that is the concept.
Framing charge, you will get an opportunity to cross-examine and all.
Yes, yes. It is there are twofold. One is if the prosecution, if the case is initiated otherwise than the police report, section 444 CRPC.
Read it. What is this earlier order?
My lord, I am coming. 244. I'm placing.
Now, what is this earlier order?
Earlier order, man.
CRLMC number 651.
That was, my lord, the petition where NBW were issued against the petition. So they have approved this Hon'Ble Court for releasing him on bail.
Okay, tell me.
444. Cases instituted otherwise than on police report. Evidence for prosecution. When in any warrant case instituted otherwise than on a police report, the accused appears or is brought before a magistrate. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Number 2, the magistrate may, on the application of the prosecution, issue a summons to any of its witnesses, directing him to attend or to produce any document or other thing. Then we will come to 245. If upon taking all the evidence referred to in section 244, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which, if unrefuted, would warrant his conviction, the magistrate shall discharge him. Nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case, if for reasons to be recorded by such magistrate, he considers the charge to be groundless. 246(1). Procedure where accused is not discharged. If when such evidence has been taken or at any previous stage of the case, the magistrate is of opinion that there is a ground for presuming that the accused has committed an offense triable under this chapter, which such magistrate is competent to try and which, in his opinion, could be adequately punished by him, he shall frame in writing a charge against the accused persons. My respectful submission, when cognizance has been taken in a case before framing of the charge, under section 244 CRPC is to be followed by the learned magistrate. Means the prosecution should adduce evidence and give an opportunity to the accused person to cross-examine.
Where does it say opportunity? It's a pre-summoning evidence.
My lord.
It is a pre-summoning evidence.
Before framing of charge, this is the situation used to be. I'm placing one judgment.
Where is the impugn order?
Impugn order is, my lord, at page 24.
Which para?
My lord, paragraph 12, last part.
Yes.
Total paragraph ସବୁ ଲେଖା ହେଇଛି କିନ୍ତୁ ଦି ଲାଇନ ଲାଷ୍ଟ ଲାଇନ 13 ଉପରଟାକୁ ମୁଁ କହିଲି.
Yes.
The difference lies in the fact that while the former is a process that is conducted in absence of the accused.
Where are you reading?
Paragraph 13 ଉପରଟା.
हाँ.
ଉପର 3 ଲାଇନ.
हाँ.
The difference lies in the fact that while the former is a process that is conducted in absence of the accused, the latter is undertaken in his presence, with an opportunity to him to cross-examine the witnesses
Produced by the prosecution. In paragraph, your lordships kindly have a glance paragraphs 17, 17. 16, your lordships kindly. Suffice it to say that the evidence referred to in section 244 to 45 to 46 must, on a plain reading of the said provisions and the provisions of Evidence Act, be admissible only if the same is produced, and in the case of a documents approved in accordance with the procedure established under the Evidence Act, which includes the rights of the parties against whom this evidence is produced to cross-examine the witnesses concerned. Paragraph 17, long one, my lord. But it is relevant. The last parts I may be permitted to place, my lord.
Yeah, have you got this judgment? What do you say?
I have not seen.
Give the judgment.
Another thing, my lord.
You give the judgment.
I am giving.
You made out a point, let us see.
Another thing, my lord. If those things are not followed, it is hit under section 460 of the CRPC.
I understand it, where, what is the point you want? He is trying to distinguish one thing. If there is a cognizance is taken in a warrant trial case arising out of a complaint, then the pre-summoning evidence also is subjected to cross-examination. Then only charge could be framed. That's what you mean to say. So therefore, he is armed with this judgment. The para 17 is the real. You give a copy, let him address. Keep it 13th. 13, 1, 3. 15th, okay, 15th.
Well, there was earlier order of interim order. Can it be extended?
No interim order. Earlier interim order is not given, no. I will If necessary, I'll quash it, but not. Yes. Keep this judgment there in that file. Yes. Yes.
Next case, my lord, that the impugned order is annexure 6.
What is this impugned order?
The case, my lord, is a case of 130 NI Act, my lord.
Hmm.
NI Act, my. After examination of the prosecution.
243-2.
My lord.
243-2.
243-2, my lord.
Hmm.
I filed a petition to send the exhibit in the check and the money receipt and signature for the to the expert for examination. To the let's see, can see the annexure to the for determining the handwriting.
Where
the
are you
exhibit,
reading?
Let's see, annexure 4, my lord, page 21, my lord.
Oh, huh? This petition you have moved.
This petition I moved before the trial court, my lord. Before the court below, my lord. And they have filed the objection, that is annexure 5, my lord. Page 22, my lord. The learned court below, my lord, rejected on the ground, my lord. On the the page 27, my lord. The last 3 lines, my lord. Page 27, my lord. The last line. Especially when though no specific plea was taken by the accused, the present petition, the accused in the court below, my lord. Accused disputing his signature neither during his examination nor in his accused statement, but bears no real significance, my lord. If lordship can see the annexure.
What is your defense?
My defense, lordship can see the page 3, my page 17, my lord. Annexure 3 series. Page 17. Page 17.
17.
17. The examination in chief, my lord. Paragraph 2. Let's see good. The contents of check already marked as exhibit 1 is not handwritten
Which
by
paragraph? Which paragraph?
Paragraph 2.
Contents of the
check already marked as exhibit 1 is not written by me, but the signature already marked exhibit 1.
Signature is your entry. Many a time this happens.
My lord.
And in a big company, director will not fill up the check. Check will be filled up by his staff and he'll sign it. What is the big difference is about?
Well, let's see. My next.
Do you expect that the person
next
who signs will...
my specific plea before the court below, my lord, that check has been stolen by the complainant, my lord. That is, let's see.
But the signature appears.
My lord.
Signature appears.
The signature that has been stolen, my lord.
Where have you said that?
That annexure 3, my lord. Sorry, paragraph 3, my lord. Then paragraph 3, so in 2010, I was building market complex and my staff Vikas Agrawal used to oversee the affair. I had kept certain blank check in my office there of the payments of laborers and materials. When I received court summons and asked Vikas Agrawal, he told me that Harbhajan Singh used to our office approaching him to take material from him.
Have you filed any FIR or anything?
My lord?
FIR, anything?
No FIR, my lord.
138 notice reply?
That reply is not with me, my lord. And then you'll next week I'll.
But we have admitted that I have not lodged any FIR against Harbhajan
that I have not
for the alleged theft of the check. I have not given any missing report of the check to the bank, my lord.
You don't have that. See, signature in the check you have admitted.
My lord, that is
not a problem.
No.
The problem. What do you want to get examined? The entries. Even if the entries are there, how that will prove the fact that it was stolen? Handwriting expert, you have sent it. Okay.
No, my lord.
Why are you? Suppose I will allow your application. Your handwriting expert, the checks will go.
The contents,
Contents are okay. Content is written by XYZ, somebody. How this fact will prove that your checks were stolen? You tell me. I will record that content in the check are written by someone else.
Let's see. Tomorrow I will verify.
Why tomorrow? Just see. What is your case? Your case is
to send the check for forensic laboratory.
Suppose I will allow it. What will you get? Everything in your favor. What will you get? Signature you have admitted. Somebody else has written the fill up the check. Even if that is proved, how you will get the benefit of the fact that the checks were stolen from you? Is that evidence sufficient to prove the fact that checks were stolen from you? You have not filed FIR, you are saying.
Well, I am admittedly I have not
138
filed any
notice
FIR.
when was given, have you said in 138 reply notice?
If a lordship can see the paragraph 3, the last two lines, my lord, I had not made any money receipt, the already exhibit 7. And the Harbhajan and this is not even my signature on the.
These are not relevant.
Well, the money receipt, well, they are showing the exhibit 7 is the money receipt and exhibit 7 is.
You moved an application for sending the check for handwriting expert.
My lord.
On the face of the admission by you that the signature is yours, even if I have been sent it, it will lead to nowhere. So therefore I'm dismissing.
The annexure, the exhibit 7 and 7/1, my lord, that is not my signature, my lord. The exhibit 7 and 7/1, my lord, that is not my signature. The lordship can see the paragraph 3, my lord. That money receipt, the signature is not mine, my lord.
My lord, the learned court will pleased to observe that the case record is a year-old record being lingered for the defense side since 5/10/2021, my lord. And now at the stage of argument, the learned counsel for the accused has come with a prayer to send the exhibits to the handwriting expert.
This is wastage of time. What is the check amount?
Check amount. 7,27,400.
Shall I send it to mediation? You will do it, finish it up.
Then I'll
or keep on fighting.
My lord, the matter is of the year 2013, my
People
lord.
are
And
saying
there is
that
lingering
So
matter.
therefore, see, through 2013 you have been fighting. You are not getting anything. I'll send to mediation if
the matter can be settled.
he may
my
not
lord.
be in a position to pay full. He may be in a position to pay entire amount with the installment.
Fact on the
Try and do it.
my petitioner is suffering with a very illness, my lord. I try to settle, my lord. If lordship can send a mediation, my lord, matter can be settled.
Think over. I will not force you, but I think that's a better course.
My lord.
2013 this is going on. It will lead you nowhere. Think over. He could successfully drag the case for 1 decade by moving this application, that application, whatever. So you think over. Shall I send it?
My lord.
The matter can be settled.
Have you sought instruction?
Well, my senior has sought instruction, my lord.
Huh?
My senior has sought instruction, my lord.
To send it to mediation?
No, if such instance come, you agree with that.
What admit?
If his senior said if such situation will come, then we will agree for mediation. Matter can be settled. Lordship can settle. Matter can be settled.
This present petition is arising out of an order. Arising out of an order whereby the learned trial court has rejected the application of the petitioner under section 243(2) CRPC for sending certain documents including the check to the forensic to the handwriting expert. This the present dispute is arising out of a proceeding under 138 NI Act, which is pending since 2013. Parties to the present proceeding have now agreed to try to settle their dispute through mediation. On their consent, the matter is sent to High Court mediation, whatever, mediation center, whatever. To, okay, when will you appear?
Then I'll also fix any date. Any date, 1 week after any date.
One, appear, mediation center, mediation. The center would fix appropriate date and time for appearing of the parties before 8. Before 8. Next, awaiting the mediation report. The matter is adjourned to 23rd of February.
The interim order to continue.
Interim order to continue. Try. If he gives the money and finish it up.
Perhaps the matter will be settled, my lord.
Let it be settled. You also try to give it in fixed installment. Give it and finish it. Yes. How many matters? Any very urgent matter out of these 4, or it can spill over to tomorrow.
Public.
Tomorrow, no problem. Spill over these 4 matters. Remaining 4 matters can spill over. Yes.
I'm appearing for the appeal mine.
Which one?
63.
Yes.
My name may reflect somewhere.
The name will reflect. What do you want? Any chance of settlement?
I have only instruction to appear matter. I have not received.
What is this dispute?
Cognizance.
Both are civil dispute and that 307 has been added. The last condition you asked that this notice to informant whether there is any scope for the both are never.
Yes, settlement.
Just let me take inspection matter.
We can send it to mediation, or you will seek instruction come.
Let me take an instruction.
Let him come with instruction. Because see, mediation, it is not a inter-se private dispute. State is also there. Why should state will go for mediation? So you, when you will come?
2 to 3 September.
Don't take much time.
The client is instructed me.
You come on 15th or 16th.
My name may be reflected.
His name may be reflected.
It's already appeared. Satyanarayana Mishra 4.
And yes, anything?
My lord, Belgium matter 64, item 64.
Yes, what do you want?
Belgium matter, my lord. NPW.
Belgium matter.
My lord.
It was a CBI matter, your lordship.
Due to some. He's there. I'll pass it. Belgium matter what?
Lordship, I record my opposition and then pass it.
Your name itself is opposition. You are there means only to, you only decide how much cost to be paid to the bar. How much?
1,000.
1,000. At least the proceedings are stalled. Let him go. You appear, how much? You will be appearing in the court below on or before 20th of February. And seek remedy available under law.
My lord, permit me to correct the cause title as Republic of India.
Yes.
Instead of.
You write down the land counsel for the petitioner undertakes to appear before the court on on or before 20th of February and seeks remedy available to him under law. Under law. Mr. Sarthak Naik, prayer, opposes the prayer. You are absconder.
My lord, on 17 November 2023, due to certain gap, contacting counsel cannot intimidate me, and I am in bed.
Opposes the prayer. Opposes the prayer. Opposes the prayer. Bas. Okay, for 1,000 rupees. 1,000.
My lord, correct me the cause title as Republic of
You
India.
correct it. No problem.
Oblige.
Next, and then
64.
2 matters remain. खत्म कर रहे थे. और क्या रह गया? 63 over, 64 over. 61, 62. Nobody is there. 61 adjourned. 62. 62. Nobody is there. Adjourned. Exhaust vote.